Test.
Good morning and Merry Christmas. So this is the December hearing of the Oil and Gas Conservation Commission. We will start, I believe, with a roll call of commissioners. I would like to take the opportunity to welcome, how do we say this, Director Leonard? Or
I'm acting as the interim.
Interim Director Leonard. Thank you very much for joining us today. Ms. Bryant.
Chair Benton.
Here.
Vice Chair Boygan.
Here.
Vice Chair Holton. Commissioner Egger.
Here.
Commissioner Hawkins.
Here.
Commissioner Jolly.
Here.
Commissioner McGowan.
Here.
Commissioner Overturf.
Here.
Commissioner Randall. Mr. Chair, I have 7 of 9.
Very well. Thank you very much. I have a text message from Commissioner Holton. He said he needs a call-in number, please.
Can you do that? I don't know. Thank you.
Enrique, you can borrow my phone if you want to text it back. Okay. All right. Thank you. Excuse me just a moment. All right. Mr. Davenport, I believe the next item is public comment period. We have some elected public officials and then some individuals who signed up. Did we get anyone who signed up on the sheet as well?
We have additional 6 persons signed up on the in-person sign-up sheet.
So, and we have how much time allotted today? Is it an hour?
Yes.
So if we do 2 minutes for everyone or 3 minutes for elected officials, we should get through everybody?
Appears so.
All right, we will do that. Would you like to start with the names?
Thank you, Mr. Chair. First 3 people on our list are all elected officials. I believe there's Representative Mike Foote, Senator Matt Jones, and Commissioner Elise Jones.
Have a seat.
All right, good morning, Commission. Thank you, Mr. Chair. Nice tie, by the way. Thank you for allowing me to speak. My name is Representative Mike Foote. I represent Eastern Boulder County, House District 12. I won't take up my entire 3 minutes, so perhaps one of the citizen commentators can take up the rest. I just wanted to say that I support the idea of doing a 6-month moratorium on granting of permits.
Okay.
Okay. I just wanted to say that I support the 6-month moratorium on the granting of permits. I believe that there's been, at least it seems to me, looking at the information and the data, there seems to be a real rush of operators coming in trying to get permits under the wire. It has almost a little bit of a feel of get in while the getting's good. And I hope that the commission will consider that and put a timeout on the granting of these permits. There seems to be a decent chance that there'll be different standards and different rules in place sometime in the very near future, particularly after the legislative session coming up, that may be more responsive to what a lot of the affected areas have been asking for. And these affected areas would be well served to have permits granted, if they are granted, under the new rules rather than the old rules. So I hope that the commission will consider that, and I appreciate your time this morning.
Thank you.
Good morning. My name is Matt Jones. I am a state senator representing Longmont, Louisville, Lafayette, and part of Erie. And I want to do something out of the ordinary today, and I want to thank you. I've been in here a number of times, as you know, and talked about how priority is protection, and we need to do that, and I don't think that's happening. But I want to thank you for suspending Crestone's Boulder County CDP due to the lawsuit. The hearing officer, I support the hearing officer's decision to postpone that hearing.
Sorry to.
That's on the afternoon agenda. I can't be here.
So just briefly, I just want to mention that, as you know, public comments are public comments. They're not part of our record. If you want this on the record, then it'd probably be best to come back and we'll swear you in this afternoon, and then you can make your statement at that time.
Can't tell you how much I appreciate you saying that and letting us know those options for us.
So you're welcome to continue, but just know that it's a public comment.
I got it.
Yeah.
All right. I don't know if I can make it this afternoon, but so I'll continue now. That lawsuit's around locations, and the CDP is all about where things are put. So I was really surprised when Crestone came in and did a 2A location assessment and 2A drilling permits applications for those sites, undermining the CDP process, the comprehensive drilling process. It was obviously a premature move. It smacks of not caring about the process and being special. And that's a real problem. I mean, people are doing this process. They should follow through. And I appreciate you telling them that they we need to resolve those location issues before we go ahead. And it's wasting a lot of our time and your time to do that. So again, I support the hearing officer's decision. I hope you stick with it and suspend the 2A and 2 permits until that lawsuit is resolved, because those are real location issues that need to be resolved. So thanks for your time.
Okay. Thank you.
Thank you, Mr. Chair, members of the committee. My name is Elise Jones, and I'm one of the county commissioners from Boulder County, and I really appreciate the opportunity to be here today. And I'm here before you once again to talk about public and local government participation in your processes, and I apologize in advance that I'm probably not going to say very many positive things. And I know it's the holiday season, but Boulder County, as you know, has been an active participant in your proceedings on 8 North and Crestone for, well, years now, including our appeal of the 8 North DSU and the additional well orders associated with it. And every step we take further into your procedures leads us into new dead ends and closed doors. Boulder County staff are here and they will give you more specific details on the things that I'm mentioning. But on behalf of my constituents, I wanted to come today to let you know that we're finding it almost impossible to meaningfully participate in the Form 2 and 2A stage in the 8 North situation. This is after you have repeatedly directed us to raise our concerns at this stage. But unfortunately, your processes prevent that. I'm also concerned to learn that statements of county residents and all members of the public who take the time and trouble to come down here and speak to you in person are not considered important enough to be a part of the official record of the proceedings. As a county commissioner, I listen to and take input from my constituents, and that impacts my decision making, and that's a part of our official record. If you're listening to the public and taking them seriously, their comments should also be a part of your public record. And if they're not, it's another false impression of openness to public input on the commission's part. One of our attorneys will be speaking deeper to this matter, but I do think it's really important that we all take a moment and really look seriously on whether or not we're treating the public right in this process. So at Boulder County, we appreciate that you very politely listen to our concerns every month. And again, apologies that I always show up and complain. But truthfully, listening isn't enough. We actually need to improve the commission's rules and processes so that there's meaningful public involvement in the effort to better protect public health, safety, and welfare and the environment in our state. Thank you.
Thank you. I'm going to ask Mr. Lyon and Ms. Jones, you may want to stick around. Would you be able to clarify for us, please, on how 510 statements work and how public comment becomes part of the public record?
Ms. Larson, would you?
Mr. Chair, this is Mimi Larson, Assistant Attorney General to the Commission. Your question with respect to how 510 statements work. Rule 510 provides that any member of the public may submit a public comment in the course of a hearing or a written comment. If a member of the public seeks to have their comment made part of the record in the course of an adjudicatory proceeding, Rule 510 provides that that member of the public would just need to be sworn in and then also be subject to cross-examination by both parties who are in the course of that adjudicatory proceeding. So there's certainly no limitation whatsoever on public comment being included in the record. Members of the public would just need to be sworn in and then wait around for cross-examination if that is the case.
Okay, thank you. Ms. Jones, I've been accused several times of copy editing what people have to say. Unfortunately, I'm a little mature, so I have to take notes. So I take notes so that I can remember what people have to say and so that I can consider that as part of these hearing matters. So thank you. Appreciate your comment today.
Kate Burk, Kim Sanchez, and Becky Roberts.
Morning, Kate Burk, Senior Assistant County Attorney for Boulder County, and I'll just follow up what Commissioner Jones was talking about, and also what Ms. Larson was just saying. So we're talking about the 8 North DSU in Boulder County that you remember we had a long hearing on in July. Previous to that, we asked for a local public forum on that, and that request was denied by the commission, but a motion was made with that denial to instead allow for the public to participate at the hearing. And so members of the public came on the morning of July 31st to speak to the 8 North DSU issue, and were not told that they needed to be sworn in, did not expect, I don't think, that those comments were Rule 510 statements, which we understood to be separate from the monthly public comment in the mornings. And as you had requested in February, they were at least invited to, I don't remember if they remembered to do this, but you invited them when they gave their public comment to give a specific docket number to which they were speaking. And then in preparation of the appeal of that hearing, we discovered that those comments would not be considered part of the record. And the issue here is, as both Senator Jones and Commissioner Jones mentioned, that up until this morning and Commissioner Benton's comment earlier today, there's never been any information provided to the public that they need to go this extra step of being sworn in if they choose to be part of the record. And instead, they're invited to come and speak. They take time off of work. They do what they need to do. And they, after the fact now, we're learning that that is not part of the record. And from my understanding of administrative procedures, if it's not part of the record, then it can have no part of your decision-making, which means you can't be listening to them, which I think should be made clear if that's what's happening. Then I just need to comment on the 8 North Form 2A and Form 2s. Again, you continuously pushed us to make our comments at that stage. We did not get notice of those because they're in Weld County, although they're within, one of them at least is within 500 feet of the county line. By the time we found out about them, the public comment period had closed. We were told that we could come and speak to you via Rule 510, but of course, 2s and 2As don't come before you unless they have been protested in some way. So we took the extraordinary step of filing a Rule 509 protest to those matters.
Sorry,
and we haven't heard back.
Please.
So I'm just asking you to direct your staff to put those applications on hold because they're subject to litigation, and to grant our request to intervene whenever they are heard.
Thank you. Sorry, go ahead.
Good morning, Commissioners. Kim Sanchez. I'm the Chief Planner for Boulder County. I'm switching gears from the 8 North to the Crestone Peak Resources applications. In early November, Crestone Peak Resources filed 3 applications to COGCC for 2A approvals of oil and gas locations and 107 Form 2 permits to drill specific wells in unincorporated Boulder County. County began receiving notice of these applications starting on November 16th and continuing through November 20th. These applications are for well sites and wells within the comprehensive drilling plan area proposed by Crestone, which, as you recall, that hearing has been postponed indefinitely pending the outcome of the county's lawsuit, which was filed in September. We'll be revisiting that decision this afternoon on the hearing officer's decision. However, because COGCC considered the CDP to be put on hold, and because the county's lawsuit against Crestone challenges the legal rights to use the sites that are proposed in the CDP, Boulder County has requested that Crestone put its applications on hold until the lawsuit is resolved. Crestone declined to do so, so the county asked COGCC staff to reject or suspend these applications, both via email and by commenting as LGD on all 110 of the applications in the database. The county has asked the COGCC to reject or put the application for 2As and 2s on hold because of the pending litigation, because of the COGC's continuance of the CDP hearing, and because a DSU has not been filed or established for any of these areas. We requested a response from the COGCC as to whether they will put these on hold or reject them as untimely, and have yet to hear back. So are requesting that you direct your staff to take the action that we've requested. Thank you.
Thank you, ma'am.
Becky Roberts, Larry Roberts, and Jan Rose.
This is a picture of Becky Roberts. This is a picture of the fire at Weld County Roads 30 and 47 and a half on November 7th, 2018. It wasn't an oil well or tank fire. It was the truck's diesel fuel that burned too hot for firefighters to approach for 8 hours. Because this location was away from homes, there was only one house within the 1 mile evacuation radius. This is why families in Watkins Farm have been concerned about the proposed Swan site location for 2 years. The Swan wellhead is proposed to be 890 feet from our evacuation road. However, the on-site truck road is only 500 feet away. If a diesel truck fire happened here like what happened in Weld County, we would be trapped. But we are finally encouraged that ConocoPhillips shares our concern. On November 2nd, 2018, Aurora Highlands developer and Conoco signed an agreement to relocate proposed drilling sites in the Aurora Highlands development to provide a, quote, purposeful separation between the industrial sites and homes. Conoco agreed to drill 3-mile laterals to reach the oil and gas. 3-mile laterals will eliminate the need for the Swan site altogether. We asked the COGCC to require an alternative site analysis before the site is approved. According to the Denver Post report, Conoco approved relocating the well pads in the Aurora Highlands development because Conoco, quote, didn't want to gamble with people's property and safety. Prosper Farms developer Barney Visser, owner of Furniture Row, where the Swan site is currently proposed, must be equally concerned about the proximity of his future homeowners and demand a, quote, purposeful separation. And Conoco must be equally concerned about not wanting to, quote, gamble with the property and safety of Watkins Farm homeowners. Thank you.
Thank you, ma'am.
I'm Larry Roberts, 714 Bowden Mile Road, Watkins, Colorado. I am the silent one. I've been to all the COGCC meetings for the past 8 months. I've listened to all the facts, the alternate facts, and I appreciate all the oil employees coming in with 98% of them telling us the same thing about how great the oil company is to work for. Their lives would not be the same without their great jobs. I agree the oil companies take care of their people that work for them, but I'm here to talk about the Swan site. The only debate to this location is to maximize profits versus the health and safety of the residents. I am sure that ConocoPhillips does not want to have an explosion as would cost them a lot of money. They do not want to have an oil or chemical spill as that would cost them a lot of money. They do want to release chemicals and contaminants into the air as that will save them money. This is why they need to stay away from schools and homes. Doing a rope-a-dope, going from 8 wells to 1 well to get approval when their lawyer has stated this site will be 8 wells. This is unacceptable. Offering us an emergency exit with a locked gate in case of an explosion or a spill is not a solution. The Colorado Department of Public Health and Environment, representing all of us, said this site is not advised. Enough said. For everybody from our neighborhood, I would like to thank Director Murphy and all the COGC members for their time looking into the swell site. We all look forward to the positive outcome requesting Conoco to move this site away from the only neighborhoods within 3 miles. Thank you.
Jan Rose. Susan Noble, Micah Parkin, and Julia Williams.
How do you do? I'm Susan Noble, 10642 Ole Street, Commerce City, Colorado. Today I want to talk with you about a complaint that I made on 11/14 at the PC North site in Brighton, Colorado. An inspector came to the site on the 15th. I had photos of dark black smoke rising from a combustor on the site. An hour later, I came back and I made video of smoke rising from the same site. This is without smoke, but that stack is where the smoke was rising from. This is a 20 well, I call it an industrial plant. That's what these look to the average citizen. The inspector found that there was no violation because he wasn't there to see it. This has to be considered a failure on the part of the COGCC's regulatory system. If it isn't seen, it doesn't mean it didn't happen. Until you have enough inspectors in place to reach a measurable complaint within 1 hour, 24/7, we cannot be assured that our health and safety is being protected by this system. This brings me to this, which is our greater concern. This is actually grown. This is 200 wells. We're actually now at 300 wells. Each one of these blocks represents the number of wells and the name of the site in the Commerce City area. If we have smoke emanating from each one of these, compounded by the smoke that rises from other wells and combustors and other equipment throughout this region, I can't even imagine what we're doing to Colorado. Thank you very much.
Thank you, ma'am. Mr. Chair, could I
Yes, Commissioner
follow
Boyd.
up? Can you stay for just a second? Did you actually talk with the inspector? I mean, were you out there when the inspector was, or did the inspector come afterward?
The inspector phoned me from the site. I told him that it's about 4 miles from us. I happened to be driving by the day that it occurred. I asked him if I could bring my photo and video to him, and he said no. In the report, he says, he also mentioned that there is a gas chromatograph on location generally, which can then measure the type of gases that are coming out with the smoke extraction. And he said he asked the staff if they had a gas chromatograph on location to analyze the gases coming from the location, and they indicated they did not. At the time of the inspection, no smoke was observed coming from the equipment on the location. That's true. It happened the night before. No violation of COGC rules were observed at the time of the inspection of the production of operations at the location. Letter sent? No. I will say that air quality did find a violation. Black smoke is not allowed.
Could I just ask a follow-up?
Yes, you may. Go ahead, Commissioner Boygan.
Air quality, who do you mean by air quality?
State air quality? State air quality?
Was there some kind of a violation citation or?
Yes, they sent me an email about that, actually, about 2 weeks later. He said that he had a very difficult time getting your inspector on the phone, even though it was his cell phone, to discuss it with him, because the inspector had told me that, in fact, black smoke rising from any equipment is not a COGCC violation. I found that hard to believe. I had contacted the COGCC, CDPHE, oil and gas liaison for Adams County, and air quality. That's a lot of acronyms that we have to get used to when we're on this side of the fence.
Mr. Chair, I'd like to request staff to just follow up with a report to us, and it can be verbally here. I'd just like to understand better what happened. I'm puzzled by how air quality could issue a citation for something that our staff thought was not a violation. It may just be different jurisdictions having different regulatory authority rather than the notion that, well, we didn't see it, so it didn't happen. I'm thinking it's more the former than the latter, but I'd like to understand that better.
So Commissioner Boygan, you're correct. Air quality, CDPHE air quality would issue an opacity violation. We don't have opacity rules per se.
Opacity, that was the word that was used.
May I ask a question?
It was opaque.
Yes, Commissioner Overturf, please go ahead.
I also wonder, is there a general staff approach to accepting evidence that's been created or compiled by citizens for purposes of enforcement suits? Is there a general rule that the inspector must see the violation with his or her own eyes? Or do we at times rely on other sources of evidence?
So the answer to that would be yes. Both.
Uh-huh.
Generally, in cases like this, since we don't have a time frame, was it, in other words, CDPHE, I know their opacity has to be a 15-minute, I'm sorry, maybe not 15 minutes. There's a certain time frame that the opacity has to occur. So just a snapshot on someone's phone, we don't know how long that happened.
If I may, extraction admitted to 3 hours to the air quality management. I captured 1 hour
Okay.
with timestamps.
I guess I can't deny that, but typically we don't take third-party photos and issues like that as evidence.
May I suggest that we take this offline and you and I can have a discussion about this after the hearing, see where we can go from here. All right. Thank you, ma'am.
Thank you for your interest.
Should I begin? Sorry.
Yes, ma'am. Go ahead.
Okay.
Sorry.
Hi, my name is Micah Park, and I'm Executive Director of 350 Colorado, reside in Boulder County. First, on behalf of the 2,350 Boulder County members, I want to ask you to reject Crestone's proposed permits in Boulder while they're under litigation. Secondly, on behalf of 350 Colorado's 16,500 members statewide, I'm going to read a petition to Governor-elect Polis that we're circulating as it very much pertains to the work of this commission. And I encourage everyone listening to go to 350colorado.org right now to sign it, or later when you get home. Dear Governor-elect Polis, we're writing on behalf of a broad coalition of organizations and with regard to 1.1 million voters who are demanding greater protection of public health and safety in our state as it relates to oil and gas development. Our elected officials and the Colorado Oil and Gas Conservation Commission have thus far failed in their duty to adequately protect the public health and safety of Colorado communities, and we ask you, our new governor-elect, to take swift measures to address these concerns. This fall, over 1 million voters in Colorado showed their support for 2,500-foot oil and gas setbacks from homes, schools, playgrounds, water sources, and other vulnerable areas through yes votes on Proposition 112. The measure came within just 5.2 percentage points of passing, despite an unprecedented $40 million opposition campaign from the oil and gas industry. This is a strong message from Coloradans demanding protective action now. We call for your leadership in efforts to increase oil and gas safety setbacks to 2,500 feet or to a distance that is in line with the growing body of public health studies and firefighters' recommendations to reduce health and safety risks, and to give cities and counties the ability to create stronger protections if they wish. We call on you to reform the Oil and Gas Conservation Commission, including working with the legislature to revamp the COGCC's mission statement to eliminate fostering in the oil and gas industry, which is no longer appropriate in the 21st century with a climate crisis. We call on you to appoint new commissioners if necessary to uphold this new updated mission, to drop the appeal of the Martinez decision and enforce it by prioritizing protection of public health and safety, to create an oversight committee to periodically review and evaluate the performance of the COGCC to ensure that it is adequately meeting its new mission, and to suspend further oil and gas permitting until the above is achieved, and to promote a just, timely transition from fossil fuels to renewable energy, in line with a recent IPCC report that says that global temperature must going to stay need to.
Up.
Okay, let me finish my sentence. that the IPCC report that says that global temperature rise must be kept below 1.5 degrees Celsius to avoid the most dire climate impacts. This is abbreviated, and we encourage you all to check out the rest of it at 350colorado.org and to sign. Thank you.
Just as a moment. I think you said earlier, you said elected, and then you had it at the end that it was, you had said it correctly that we're appointed. You might want to correct the petition. So I think you said that we were elected commissioners.
No, Governor-elect Polis. It was Governor-elect Polis.
Okay, I think earlier though, you said elected members of the commission. So you might want to just check the petition.
Julia Williams, Bess Marr, and Amanda Ulmer. Sister Elizabeth Furr, Cory Green, and Laurie Anderson.
Good morning. My name is Elizabeth Furr. I'm a Franciscan sister and a board member for 350 Colorado. Thank you for the time. I am relieved that you have demanded the oil and gas companies to pay for the cost of closing the wells. It is a recognition that oil and gas is not king and cannot destroy and take for its greed. The science and economics have told us clearly in the fourth national assessment that we must stop removal of fossil fuels from the ground and not put them in the atmosphere, which is destroying the planet. Fossil fuels are not paying their true cost. We need to transition rapidly to a sustainable plan in a just and equitable way as quickly as possible. The studies also not only acknowledge that the cost of transition is half the cost of continuing on fossil fuels, and that stopping the pollution of our planet will save many lives. The role of regulation of resources, Department of Natural Resources, is for the planet and all creation, and not for a dying industry. I ask this to be put on the record. Thank you. And before, I have seen other members ask that, and they have not been told that it won't be put on the record. So I am asking it to be put on the record. Thank you.
Thank you.
I was heading up here. Make me nervous. Good afternoon. My name is Cory Green. I'm part of Watkins Farm and the Swan application. I'm a Colorado native, born and raised. Aside from time in the Navy, working in DC and deployed overseas, I spent most of my life here in Colorado. Currently work at Buckley Air Force Base. I'm an intelligence officer for National Geospatial Intelligence Agency. My wife and I have property that borders would be the well site. But now you've probably heard all the issues with the environmental and potential hazards and all that stuff around our community. I want to talk about progress today. So I went to the Navy, turned 20 in boot camp. I progressed, graduate college, worked numerous civilian government jobs, talked about the Pentagon, Middle East, progressed what I call the adult ladder. Made good choices in life and have had a lot of luck from moving from my parents' house to renting a house to buying houses to my property out now at Watkins Farm. I talk about progress. Some of the things I talk about, like lead-based paint. We don't use lead-based paint anymore. Why? Because it kills people and it's illegal. We've learned from that. We didn't quit painting. We just made choices and make better paint and not use lead. Same with asbestos. We no longer make building materials with asbestos, but we're still building. Automobiles, airbags, seatbelts, things like that. Didn't used to use them. Now we do. We've progressed. But here we are, almost 2019. The oil and gas companies have not progressed. They're telling us oil and gas wells are safe to put next to communities. They blow up. They catch on fire. It's human disasters. They're caused by humans, caused by environmental things that cannot be necessarily, no matter how much safety these companies try to put into them. Oil companies have the technology to drill vertically, and in this case, the well away from our community, and a planned community of 3,000 houses. So there's our community, 3,000 new houses in a nice community that's planned. They want to put an oil and gas well right in the middle of it. no amount of safety can stop that. I hope the sister doesn't get mad at me on this one, but I'm not against the oil and gas companies. I enjoy driving, cooking, and all the things produced by petroleum. I even like drinking out of plastic straws, but I'm willing to progress to would be paper straws. I think it's a great bargain to be able to drive for the cost, what it takes to get oil and to do those kinds of things. Start talking about progress as a society. I think we can do better. This commission can do better, and I really appreciate your time. And I hope you'll consider the SWAN application and a possible change in where they want to put it. Thank you.
Thank you.
Good morning. I am Laurie Anderson with the League of Oil and Gas Impacted Coloradans. I'm here today to read a prepared statement from a group of citizens we represent who were unable to attend this meeting. Dear COGCC commissioners and staff, we are Timnath residents who live near Great Western Operating Company's proposed 28-well Wizard FD project in Larimer County. Our initial concerns related mainly to the size of the project and proximity to the floodplain. However, that is not why we felt it necessary to reach out to you directly. Great Western has represented to you that their right to construct this site is derived from a surface use agreement. Their attached memorandum of agreement references an unrecorded SUA between Great Western Operating Company and the alleged surface owner, Westward Development, LLC. That agreement was signed by Mr. Dino DiTullio as manager for Westward Development. According to public records, it does not appear that either Westward Development nor Mr. DiTullio currently own or have ever owned the property on which the proposed 28-well pad is to be located. If Westward Development and Mr. DiTullio have no legal ownership rights in the property, the referenced SUA cannot convey any right to Great Western to access the land or conduct operations on the property. We have prepared copies of key documents for review, which I've just handed Ms. Prine. These applications have already passed completeness review by COGCC permitting staff. We trust that you will ask staff to look into this matter and, if confirmed, reject all pending Wizard FD applications. Commissioners, while this may be an isolated incident of not recording the relevant deed, it is just one more of a growing list of examples of operators rushing to obtain permits without performing basic due diligence, such as ensuring their rights are protected through properly recorded public documents. As the regulatory body, we look to you to establish and enforce rules and policies which ensure that oil and gas operators in Colorado act responsibly and in the best interest of Colorado citizens, natural resources, and property rights at all times, even before they obtain a permit. Thank you for your time and attention to this matter.
Thank you, ma'am. So, Ms. Bryan, we do have a copy of that.
We do.
And Director Larson has it. Soon we'll do some more investigation on that. Appreciate it. Thank you very much.
Mr. Chair, we've completed the online signups. We're going now to the in-person signups this morning. The first three people I have are Ms. Kelsey Waslenki, Ken Wanstolen, and Jeremy Landorf.
Thank you for your time this morning. This is Kelsey Wazelinski from Jost Energy Law on behalf of Highpoint Operating Corporation. I'm here on behalf of Highpoint to discuss three pooling applications, and I'll read those docket numbers: 1812-00936, 1812-00937, 1812-00957. These are all uncontested pooling applications. They were filed in October of 2018 for the December hearing docket. Proper notice and publication was done by Highpoint. Rule 511 was filed. All of the APDs are approved. These pooling applications are seeking to pool wellbore spacing units in Weld County. On Thursday and Friday of last week, the hearing officer continued all three of these applications, not due to any issues with the 511 testimony, but simply due to lack of time by the hearing staff to review the 511. We're not here against the hearing staff. We understand that they're overburdened and overwhelmed right now. But we are here to ask for limited time on your agenda to present the testimony to you today. And the reason being that Highpoint is under contractual drilling obligations for these wells. The drilling obligations require spud to occur prior to January 28th, 2019. So the continuance of these three pooling applications does present real concerns to Highpoint. We understand that there is time on your agenda, that several contested matters have settled, that the rulemaking tomorrow is uncontested, and therefore we would ask for 5 to 10 minutes I have packets of the application, 511 testimony, all of the materials in all three of these pooling applications, should you want them. And Highpoint witnesses are available at any time on your agenda to come and present the testimony. So again, just respectfully asking for a few minutes to accommodate the real contractual concerns of Highpoint for these matters. Thank you.
Just for clarification, Ms. Wozlenki, would that be either today or tomorrow?
Correct, anytime.
All right. During one of the breaks, I'll chat with the director and the hearings manager.
Thank you.
See what we can do.
Mr. Ron Stolen, you're not going to make a comment? Okay, thank you.
Darn.
Jeremy Landorf, Marie Powell, Ed Ingvey, and Joby Rittenhouse.
Mr. Ingvey contacted me this morning. I believe he's been unavoidably detained, but he's just requested that he also just have a moment to speak tomorrow during the hearing cycle about the Third Creek gathering system.
Certainly.
Thank you.
Mr. Chair, I don't have any additional in-person signups with me. I don't know if we've had more signups since the meeting began.
Anyone else who's come in today who wants to speak and did not sign up?
I would like to.
Certainly. Come on up.
Thank you. This is great. Appreciate it. I came 200 miles to be here today. My name is Jennifer Moore. I live in Glenwood Springs, Colorado, and I would like to address the commission. I'm here to state very strongly how important it is that the issue of oil and gas industry impacts on public health and safety. My comments also include all forms of emissions and pollutions commonly associated with some of the drilling and fracking operations. This is a health and safety issue. It's also a moral issue. Does the oil and gas industry have the right to poison families, especially our children, who are unfortunate enough to happen to end up living and working within drilling sites? Several comprehensive studies have shown that a bigger setback does help. Are the emissions from these well sites acceptable just because the industry claims they are safe? How many industry supervisors, corporate owners, how many of you have lived within short distances of wells and raised your family in a home, or your children go to a school that's too close to wells? Having a lease doesn't automatically make it morally right to drill. A long history of accidents show a clear pattern of industry-wide carelessness, a severe lack of inspections, a cavalier attitude towards public concerns, and cutting corners in order to save money. It's very clear that the industry management is not concerned with the air quality and water contamination issues, the potential for blowouts, fires on site, leaking chemicals, massive amounts of truck traffic, and other to and from the sites, and the long-term damage to these neighborhoods, the residents, and a host of well-known health and safety and environmental issues. I say no. Citizens are starting to pay attention. We are watching, we are taking notes, and we vote. I know we can't vote for you people, but that's what we're working to have a little bit more input so that there's some fairness. It is duly noted that this commission has never denied a well permit. The COGCC has a large number of pending permits to be considered in the next few weeks. I challenge you to turn down permit requests that violate common sense and/or public health and safety concerns. This is a moral issue, and I demand you finally become accountable and begin to do the other portion of what I hope is your job, which is to protect the public. Thank you very much. And I would like to submit a copy of this for the record, please.
Excellent. Thank you very much.
Thank you very much.
Thank you for making the trip over.
Thank you. I appreciate being able to get in. I wasn't able to sign in online.
I went to high school in Glenwood Springs. I sure miss that place.
Well, I do the pool.
The great pool. Thank you. We have one more.
Good morning, Commissioners. I apologize. I was on the written list. I'm here. My name is Joby Rittenhouse, Beatty and Wozniak, 216 16th Street, Denver, Colorado. I'm here on behalf of SRC Energy, and this is with regard to docket numbers 181, 000, 737, and 739. These are two separate pooling applications filed by SRC. One is for a drilling and spacing unit that is on the consent agenda for this month. The other is for two wellbore spacing units that have been approved. Similar to the request by Highpoint, and again, I apologize for the inconvenience. We understand the stress that the staff is under with regard to all of these applications and frankly, everything in front of them. 511 testimony was filed for both of these matters in October. So respectfully, we would request additional time at some point, either today or tomorrow, to present on both of these matters. We will have witnesses available and in support of those applications. Thank you.
Thank you, sir.
I don't have anyone else.
Do we have no one else? Very well. Thank you very much for your time and your comments today. Ms. Prine, I have next on the agenda, Commissioner request for additional information on Triple Creek flaring.
Is Mr. Lewis here?
Lowell Lewis.
Mr. Chair, I did speak with Mr. Lewis and gave him a time of 10:05 because that's what was on our agenda. It may just be that he's not here yet.
Okay, very well. Perhaps we wait. We'll take our break now and then convene then. And by then, perhaps our Commissioner Randall will have shown up and we can follow up with the Executive Director's report as well.
Mr. Chair, if I could, Commissioner Holton, did you get in by phone? Nope, I thought I
heard a
him
connection.
chime
Okay, you may have lost him.
May
Very
I,
well.
may I,
Yes.
before we take our break, I just want to make sure that we're being explicitly clear. Despite the requests that we've received today that generalized public comment to be, quote, made part of the record, I want to clarify that something can only be made part of the record where there is an actual proceeding where a commission decision is being made. And general public comments about the way that this commission conducts its business or the way that oil and gas operations occur in the state is not necessarily going to be placed within the record of a docketed proceeding. I just want to make sure that we're being clear with everyone about the status of their requests.
Yes, Commissioner, you're correct. All of our public comments are captured on our YouTube, and so they are part of a record. You can go hear them. The commission refers to them. But if you want to be placed on the record for an adjudicatory matter, then you have to go through the steps of being sworn in and being cross-examined. Did I get that correct?
That's correct, Ms. Prine.
Okay, thank
you. Thank you.
Very well. Thank you, Commissioner Overture, for clarifying that. I believe we were talking about having a break, and perhaps by then Mr. Lewis will show up. Very well. Then we don't need the break yet. Sorry, Commissioner Williams. Well, soon enough, though. All right, very well. Shall we proceed?
I appreciated the dramatic entrance of Mr. Lewis.
Okay, so now it's a commissioner request for additional information, re the Triple Creek flaring. with Mr. Lewis and Mr. Leonard. Right up front. And if you'll give those to Ms. Bryan, that would be great.
Good morning. Is the volume okay? Take that as a yes.
I think so.
Okay. Before I begin, you should know that after 3 years of exposure to oil and gas projects, regulations, and jargon, and probably 6 presentations to this commission, I still consider myself to be a newbie. Someone who knows this business intimately may be able to find my statements to be questionable or possibly even incorrect. However, I have consulted with knowledgeable parties with both the COGCC and the CDPHE, and I believe my statement to be factual. Last May, I received an email regarding a CDPHE issued public comment period detailing Extraction Oil and Gas's request for 4 permits for the amount of volatile organic compounds, VOCs, and hazardous air pollutants, HAPs, that can be released and the volume of natural gas that can be flared at the Triple Creek Oil and Gas site in Greeley. If you remember, in October of 2016, after much controversy, the COGCC issued a revised approval of Form 2A reflecting Triple Creek's listing as the first Front Range site, which qualified for the additional protections as a large urban mitigation area. Extraction did construct the plant, culminating in the completion and production at all wells, at all 22 wells. They moved off site about a year ago. We had lost the battle, we had lost the war, we thought it was over. But that email brought me back to you, to the COGCC on July 30th of this year, when I reported that during the single month of December 2017, Extraction had flared 109.8 million standard cubic feet of natural gas and released over 60 tons of volatile organic compounds. I asked why it happened and how we could prevent it from happening again. During the coffee break, Director Murphy introduced me to Community Relations Manager Mike Leonard and directed that he work with the CDPHE to determine what had happened to cause such an extraordinary increase in the volume of natural gas being burned and wasted during a 1-month period. While researching CDPHE personnel on my own, I discovered more disturbing information. From October 11th, 2017, when Triple Creek's first well began production, until July 16th of this year, when the 4 permits were approved, a period of more than 9 months, Triple Creek's emissions were not being regulated by either the COGCC or the CDPHE. The only agency with regulatory authority during this phase of flowback, possibly the most dangerous stage of oil and gas development, was the U.S. Environmental Protection Agency. And the EPA's only requirement was that the operator control emissions with air pollution control equipment. In other words, by flaring the natural gas with the standard emission control devices that they were already using, Extraction was able to emit virtually unlimited pollutants without regulation or fear of enforcement actions. I also found that we at Triple Creek are far from an unusual case as regards excessive harmful emissions during flowback. To the contrary, it seems that this is a pervasive practice found in many locations much larger than Triple Creek, the Wattenberg Field, or even the Denver-Julesburg Basin. Incidentally, I make reference to 5 different articles from newspapers throughout this presentation, and they're all attached to this text as part of the packet. The first one, the Wall Street Journal reported that Texas's Permian Basin, the nation's largest oil and gas field, burns roughly $1 million worth of natural gas every day, an amount sufficient to supply needs of states such as Montana or New Hampshire. Worse yet, the flaring also produces greenhouse gas emissions equivalent to 2 million cars. In mid-September, Mr. Leonard sent his report to me and to you commissioners. To summarize his findings, the cause of Triple Creek's extraordinary December flaring volumes was a confluence of malfunctions and upset conditions on the DCP midstream sales lines, while multiple wells were being brought into flowback. This combination of circumstances would have caused a catastrophe if not dealt with immediately, and the only resolution was to waste massive volumes of natural gas. In my conversations regarding the December problems at Triple Creek, I have been told repeatedly about the inadequacies of the midstream infrastructure. It appears likely that weaknesses in the gas sales lines may be a common cause of malfunctions and upset conditions that require massive flaring to avoid disaster. But in spite of sales line failures, massive pollutant releases, and resultant health problems with neighbors, including my own family, increasing numbers of oil and gas sites in suburban areas continue to be approved. These safety and health problems related to flaring will likely worsen as drillers rush in to beat the inevitable transition to renewable energy sources. And flaring will stay with us as long as the price of natural gas stays low, the gas handling infrastructure remains undersized, and we continue approving projects by the likes of Extraction and Crestone, who shoehorn their sites into tight urban and residential areas. Their business models place vulnerable children and elderly adults in adjacent residential neighborhoods in harm's way as they are exposed to the hazards of this extraordinary flaring process. We thought we had passed the worst of it at Triple Creek once production started, only to find that the extraordinary flaring of natural gas and release of other pollutants had occurred and will likely continue. In fact, during August of this year, 10 months after Triple Creek began production, we again observed flames over the tops of the ECDs at Triple Creek on two separate occasions. Looking at the big picture, the following recent energy headlines have become more relevant to our own concerns for our own oil and gas concerns on the Front Range of Colorado. Number one, for the first time in 75 years, the United States has become a net exporter of oil. Number two, at this time, the U.S. is the world's largest petroleum producer, surpassing Russia and Saudi Arabia. Number three, greenhouse gas emissions worldwide grew at an accelerating pace in 2018, putting the world on track to face some of the most severe consequences of global warming sooner than previously expected. And number four, Pennsylvania Governor Tom Wolf has proposed new regulations aimed at curbing air pollution and greenhouse gas emissions from their vast natural gas exploration fields, regardless of Trump administration moves to relax federal requirements. Blessed with solar and wind energy, we Coloradans have a unique opportunity to be part of the solution to both global climate change and local health and safety issues associated with the extraction of petroleum products. By beginning to curtail Colorado's excessive production of oil and moving aggressively toward renewables, we can begin the transformation of the Colorado Oil and Gas Conservation Commission to the Colorado Energy Conservation Commission. To circle back to my original question of last July, extraction flared huge volumes of natural gas and released tons of VOCs into our neighborhood because it was essential to do so. They could have flared less, but they certainly could have flared more. After all, the state had no regulatory authority for emissions, and extraction feared no enforcement actions. But for me and my family, given the knowledge and experience I have gained over the last 3 years, and knowing the predatory site placement practices of the likes of Extraction and Crestone, I would want my home to be at least 1/2 mile from the increasingly common mega developments, which I define as 10 to 20 or more wells on a single pad. As always, my most grave concerns rest with the Weld County Middle School children at Belo Romero, adjacent to Eastern Greeley. They and the children growing up near huge new oil and gas developments in residential neighborhoods in Adams, Boulder, Broomfield, Larimer, and Weld counties have only us to protect them, and I fear we are failing them. Thank you.
Thank you, Mr. Leonard. Any questions about the report or? Commissioners? Commissioner Boygan.
Yeah, I have a couple of questions. My sense of the report was that it largely consisted of excerpts of reports that Extraction provided to you. Is that correct?
It's reports that were provided by Extraction and from the COGCC database.
Okay, because it reads in several parts as though it was the company speaking rather than the commission.
So the attachment A is directly from the company. That was I requested the upset condition, why there was an upset condition on those particular days, and that was relayed to us. I also requested daily production reports rather than just monthly, so I could go through and see exactly what days the excessive flaring was.
So my main question is, do you agree with Mr. Lewis's assessment that there is no effective regulation or enforcement of emissions or flaring on this or any other site at least during the flowback period, or maybe during any period?
There is effective regulations. However, this is during upset conditions. The upset condition being the line blockage.
Right. Meaning that the gas could not be transported.
The gas could not be transported or sold, correct. And in the flowback stage, shutting the well in could damage the well irreparably.
So operators are permitted to flare in those circumstances?
That's correct.
Is there any oversight of that process? Do they have to report? Is there any limit?
They do have to report their flaring, yes.
And is there a limit that they can't exceed, or either in terms of quantities or number of days, or?
Not through COGCC, no.
Or CDPHE, your knowledge?
To my knowledge, that's correct.
You don't mind if I butt in periodically? Thank you.
It's somewhat of an open discussion, although we probably do need to make sure that you raise your hand so that we can recognize you for the record, Mr. Lewis. So
yes,
it's just a matter that we have lots of people that listen and we're not certain exactly who's speaking.
Understood. Thank you.
So I'll just conclude. What I'm inferring from all this is that no violation occurred as far as our rules requirements are concerned.
There's no violation of COGCC rules. No.
Was there a best practice concept here that may not have been followed, or I guess what I'm trying to get at is, do you think that the operator did anything wrong, that this is improper behavior, or are you saying that this is basically what happens?
There are methods or things that the operator could have done differently, not bringing on these wells all at the same time like this may have prevented some of it. I don't know that it would have prevented all, but bringing on this many wells with, I think they had 8 wells already in production, and they brought on 10 more in a short period of time. Could have alleviated some of this.
Did they have, was it a flare or just, sorry, Commissioner, just saying, was it a flare or an incinerator that they had on the Triple Creek site?
It was an enclosed flare incinerator. Actually, I think they have 2 or 3 at the time. Am I correct, Mr. Lewis?
There are at least, right now, there are 6 that are available. I'm not sure of the number at that particular time, but they had multiple ECDs in effect and available for use. However, they weren't all interconnected until later on. And so it seems as if all the burning was taking place from usually one ECD, one, sometimes 2. That's how we were able to get the pictures from my last report showing the flames above the top of the ECD.
Mr. Egger.
Mr. I guess, Acting Director, just a couple of questions for you. First of all, in your opinion, they may not, if they hadn't brought on as many wells at the same time or in a short time period, it could have prevented it. Is that something we oversee or we have any regulatory authority over?
We do not direct, we don't have authority as to making an operator not bring wells on.
Okay. And then in attachment A of the response letter where it lists the problems with the gathering system, operational issues due to freeze ups, plant shutdown, operational issues due to freeze up, all those things, that's a gathering system or even a plant. Is COGCC, do we regulate those types of, or I guess we wouldn't regulate an error or a malfunction, but do we regulate the gathering in those lines?
We do not. This is midstream.
And then I guess lastly, and this is even more, I'm getting more and more general here, but we talk a lot now, I think when we're looking at these sites, these well pads that have a lot of wells, we do tend to ask questions about takeaway capacity, but they seem general to me. In reviewing Form 2 and 2As, how specific are we reviewing takeaway capacity and understanding, how many wells should come online at one time, or how often these kind of malfunctions could occur?
I'd like to defer to our engineering manager, Ellsworth.
This is Stuart Ellsworth, engineering manager at the commission. This is something we're trying to work with operators on, trying to understand that at the early stage on their takeaway capacity. We're engaging with the 2A. There's 2 parts to that. We have the Rule 805 that talks about green completions, and that they are to, and that's the hydraulic fracturing, that as soon as practicable, they're supposed to put saleable quality gas in the pipeline. So that's kind of the basis that we're asking this question. And then, of course, we have the 912 rule that talks about waste of resource. So we currently have a policy on our page that tries to get at, I believe it's about 5 questions, trying to understand that economic perspective of not getting the gas into a pipeline and combusting it. And so that's kind of where we are, trying to define this as waste of resource. And so it's an engagement we're trying to do. What's hard to understand at the early stage is how an individual well might flow. And we're having discussions with our operators. The expression we use is choking back the well, flowing it at a slower rate, so that the rate at which the well is flowing is matched with what they can get into the system. There's other complications. But
Is there any method of follow-up based on the information that an applicant may provide on a 2 or 2A, or discussions that you're having, a follow-up that we can see if those questions are sufficient, or if those questions are answering what we need answered?
Well, in an empirical sense, what we look at is how they've reported their wells. From the standpoint of their monthly reporting, they report how much they've produced, how much they've sold, how much they use on lease. They use some of the gas to operate their equipment. And then, of course, the flaring volume. And that's what we're kind of looking at sort of on the back end.
So when they put a date down that says this is the first possible date we can get saleable gas or whatever, are they meeting that? Do we know if they're meeting that date?
I don't know the direct answer to that question.
Yeah.
It's something we're trying to understand and grapple with right now. We're looking to revise and engaging with industry on our current policy, our flaring policy. There's that piece of the puzzle. And then one of the requests we've done with the SOGR review is we have asked them to look at our rules and audit them, which that's SOGR. It's an acronym for state regulatories. We've engaged with Groundwater Protection Council and COGCC, the sort of national organization, to engage with several states and compare our rules to other states.
Yeah. And then just one more question, Mr. Leonard, the operator is required to report that flaring, but that's after it occurs in a situation like this, right? Because they had to flare for safety reasons?
Correct. They have to report the flaring on their monthly production reports.
Monthly production.
Correct.
That's all I have right now. Thanks.
If I may, Commissioner Boygan.
You're the chair.
Now that I have Stewart up here. I'm curious about it, and just somewhat this question around the drilling and completion procedure when that gets reviewed. Is there a place within our current rules and regs that we would have the opportunity to put something on conditions of approval about the completion process or number of wells brought on, or perhaps a process hazard analysis that would say in the event of a pipeline blockage? Because it's clear to me that extraction's set up to sell the gas, and it's the only reason they had to flare this is because they couldn't sell the gas. But then Acting Director Leonard said, well, they might have sort of not brought on all the wells at once, or you suggested something which I think some operators do, in which they control the flowback rates. Is there some place we can have that discussion with operators within the existing framework of our rules?
I think
that's a broad question. I'm sorry.
Yes, but it's a good perspective question that I think one that we do need to tackle because of the variety of, if I could use it this way, the scenarios by which operators end up flaring. One is we use the expression freeze. If you have a high flow rate and you've got any kind of liquid in there, hydrocarbon liquids, even water, and you run your system and you run through a bend, you can have a pressure change and that could cause a freeze in the line. Most of what's happened, you can have it on the well pad, the individual well location, but you can have that freeze occur in the gathering system. And that's where a lot of these freezes seem to be occurring. And so it's a little outside of the operator's control. And so there's those situations. Then there's the kind of characterization that the director implied, that the individual well pad is bringing on a volume, and that's a volume greater than can be accepted by the gathering company. That's where the choke back situation. So what I've tried to describe right there are two situations. One's kind of a maintenance situation of that gathering system. The second would be the fact that the wells are just flowing at a high rate initially. So but getting back to your question, we could apply permit conditions of approval that say we can apply conditions of approval to establish that engagement and maybe work towards coming to solutions that you're trying to describe.
That would be a great place to start, would be to engage. We certainly don't want to end up like the Permian Basin. I mean, to me, it's staggering the amount of, and they're projected to, I think next year to flare something like 600 million cubic feet a day into the atmosphere next year. It's just a staggering amount of gas that gets into the atmosphere. So certainly worth us taking an opportunity to visit that. Is there something we can do within our existing framework to manage the flow back or mitigate the possibility of having an upset event occur like this, so it reduces the opportunity for flaring?
Right, and I just want to reaffirm that what we are doing with industry right now is working to revise our current guidance that on flaring and venting, how Rule 805 and 912 are to be applied, so we are working in that vein.
Okay. Mr. Lewis, I saw your pen go up, so.
Thank you. A couple of items. One, as regards green completion, much of my information on the lack of any state agency having oversight or at least regulatory control during this period from when flowback first starts on the first well until the 4 documents are signed and authorized. Green completion is an or situation. It's not an and. So as explained by Jennifer Maddox with CDPHE in her quite extensive response to my questions over the phone, she gave us some detailed answers. Mr. Leonard has this document as well. And she says, under federal rules, extraction would be required to control these operations with air pollution equipment or use green completion techniques. If you are already using the ECDs that the EPA seems to have as their only requirement, why not just continue? There's no additional effort required whatsoever. And secondly, why does a citizen have to come before you to tell you that extraction flared 110 million cubic feet of natural gas during last December? Why didn't some switch flip? Why didn't some alert be sounded? And now the same thing that we're asking regarding this at Triple Creek again, 9-month period of time during which neither the COGCC nor the CDPHE had regulatory authority over the emissions. Why?
Mr. Chair, could I follow up?
Yeah, Commissioner Boygan, go ahead, sorry.
That's actually a great segue to the question I wanted to ask. It's my understanding that Triple Creek is inside the Greeley city limits. Am I remembering that correctly?
Yes.
So it's an urban site surrounded by neighborhoods. And so my question is for Director Leonard and Acting Director Leonard and anybody else on staff, maybe Mr. Ellsworth, in addition to the waste issue, does flaring present a safety or health issue? And if the answer to that is yes, should we be considering treating it differently when it's in locations like this as compared to locations that are not in urban areas?
So I think it's important to note that the flaring is being performed with combustors that are 98%, at least 98% efficient as per CDPHE's rules. We didn't have the smoking situation here, although there were flames that came out of the top of the combustors. I don't remember how many times. Mr. Lewis can remind me how many times he saw that.
Once, I'm sorry.
Go ahead.
Go ahead,
Okay.
Mr. Lewis.
Once prior to my initial presentation to you in July, that's the one that we had the picture of, and twice since then. And of course, obviously, I'm watching the site maybe a total of 12 minutes per day.
So in getting back to your health and safety question, it's potentially more of a safety hazard not to flare and potentially overpressurizing equipment on site when the malfunctions happen downstream.
Perhaps maybe a larger risk on the downstream operations, because on site, those, for the most part, the wellheads are designed to accommodate whatever shut-in pressures they had if they had to shut the wells in.
They are, but an instantaneous shutdown could be.
Could be potentially an issue.
Yeah, and it's also important to note that DCP has been regularly expanding their system. It's my understanding they put one plant on in early 2018, and they either put it on or expanded it. I can't remember, and they're planning on building another plant to handle more gas.
I think when you consider where Colorado is, we use the Permian Basin as a number of examples. We're a lot further along in setting up that takeaway capacity so that we don't end up like the Permian Basin with a lot of flaring going on. So,
and I think if you look at the chart, you'll notice as well that, let me see, on, can't remember the exact day, 17th or 18th, I'm sorry, the 24th, that flaring went to 0 when takeaway capacity was adequate.
Mr. Lewis?
Mr. Leonard is correct in citing the ECD's manufacturer's percent efficiency. Everyone seems to use the 98%, although I have documents that say it's 95. But 98% of what? And so then the remainder is 2% of what? So 2% of 110 million cubic feet is 2.2 million cubic feet of natural gas then that were in effect vented into our neighborhood air. Also, 60 tons of volatile organic compounds. And I have not addressed the HAPs, but she's saying, once again, Jennifer Maddox on the same letter to me cites approximately 1% by weight is released of the HAPs. It's been a long time since college chemistry. I'm not going to tell you I'm any kind of authority on this, but obviously there are releases of some pretty bad pollutants into our air in an urban residential area. We have 22 wells, and you're considering sites that are much larger.
May I, Mr. Chair?
Yes, Commissioner Overturf.
Well, first, Mr. Lewis, I'd like to thank you for your hard work and your very detailed presentation. I appreciate the amount of effort that I can tell you've put into tracking down the facts and bringing them to us. And so I wanted to express my appreciation to you.
Thank you.
I would also say that this is something that I find so incredibly frustrating. I understand that there are situations where flaring is necessary for safety reasons. It seems to me that we are doing an insufficient job of trying to create appropriate incentives or to create safeguards that would prevent flaring in more instances where we could perhaps rein it in. And so I really do hope that we approach this issue in a more thorough way and think about how we can include permit requirements that require the identification of takeaway capacity prior to engaging in some of these activities, or I'm not sure exactly what those permit conditions should be. And I recognize there are mechanical reasons for flaring versus kind of capacity related reasons for flaring. But generally, this is a situation that I think we should be doing absolutely everything within our power to avoid, not only because there are air emissions that are being completely unproductively emitted. It's not as though there's even any value to, at least emissions that are coming from a car, there's some value to a person of getting you from point A to point B. Here, these are just emissions where they're not actually providing much value to our economy, which is part of the reason that it's so frustrating to me. And then also because there's such a fundamental and non-negotiable prohibition against waste in our statutes, recognizing that my understanding is that gas that's flared in situations like this isn't subject to severance tax payments. And so there are these resources that are being completely wasted and not providing any actual value to the state. So I do hope that this is something that, Stuart, you can help me understand what the options are that are available to us and what it is that we can do to get a better handle on this situation, because it just breaks my heart to see this much gas being flared.
Mr. Chair, could I just make a brief?
Yeah, just a couple of things. Sorry. Just a second, Commissioner Morgan. Go ahead, Commissioner Morgan.
I was just going to say, I'm not sure I agree with Commissioner Overturf's characterization of the lack of value to flaring. I think in addition to the safety issue that Acting Director Leonard has already highlighted, it's my understanding that flaring in many instances is necessary in order to produce the oil. And so if you had to shut in the wells and potentially damage the wells, then you're not producing the oil either. So I agree that flaring is a challenging issue and something we ought to be thinking hard about, but it's not, I don't think it's as black and white as you portrayed it, with all due respect.
Mr. Leonard, anything you care to add to that?
Not at this moment.
Okay. And it is a very, just a moment, please.
Mr. Chair.
Yeah. Commissioner Hawkins.
Just wanted to ask if we were to start putting in permit conditions, especially in urban areas, to request the operator to minimize the amount of flaring even during upset. Obviously they have some control over bringing some of the wells on before they start flow back. So before there's any kind of damage that might occur. I think there are some operations that the operator can control to minimize flaring, and certainly we should be requiring them to take all the steps that they can to minimize the amount of flaring, particularly in urban areas. So I would encourage us to try to put some kind of permit conditions around that. I'm not sure exactly how that would be worded, but I think there's definitely something the engineering staff could work on to try to minimize that.
Very well. I think so. A couple of things that come to mind. One, as Commissioner Boygan pointed out, and Commissioner Overturf, flaring is something that we don't want, although it is a very complex issue with respect to the value equation. I think we did touch on it briefly. If there's things that we can do within our existing framework to address in conditions of approval, have some discussion about the completion process hazard analysis, something like that. So I think if there's no further questions back, we can summarize it with a request to perhaps that our engineering department might be able to come back with us with suggestions on policies that we would be considered during part of that Form 2 and Form 2A process for approval. that be a reasonable request?
Yeah, we're happy to do that. I kind of feel compelled to say we already are doing some of that on
No
some of
doubt.
the perimeter scenarios where infrastructure doesn't exist. We are limiting so they've got the spacing order approved for numerous wells. We are restricting it to a single well scenario. You can you can drill and complete this first well, and you can produce the gas, flare or produce the oil, flare the gas on the single well to hence define your economics. So you can then define those economics for the full development and build and have a cost basis to build out the pipeline connection. So then you have takeaway. So that's one example of how we've begun to engage with the perimeter operations when on the outside of existing infrastructure.
All right.
So we could expand into what you all are directing.
Yeah, a little more expansion into that area. And I think, as it was mentioned, I think that North Dakota had some rules and regs on emissions. Also would encourage you to see if there's anything can be gleaned from Alberta. The Energy Utility Board up there has they have some information and regs on and policies on flaring as well.
The folks from the SOGR review, North Dakota is on that panel, and I know Alberta is a participant in IOGCC.
Excellent. Okay. Thank you very much, all of you. Mr. Lewis, thank you for coming.
I wish I could say it's a
we'll keep
pleasure.
this at the forefront of our actions with respect to completions here on the Front Range. I appreciate that very much. Thank you.
Thank you.
It does say on our agenda that we have a break, and just in time for Mr. Randall to take a break, and he will come back and look forward to your executive director's report at that time. Thank you very much. We reconvene in about 15 minutes at 10:50. And just to check whether or not we've been sort of back and forth, Commissioner Holton, are you connected to us today? Apparently not. All right. I think we can go ahead and get started. I'm sure Commissioner McGowan will be here shortly with a report from the Executive Director's Office.
Great. Thank you, Mr. Chair. Good morning, Commissioners, members of the public. Bob Randall for the department. And just a note for the Chair, Commissioner McGowan said she was going to be away for about an hour. She has a matter over at the Capitol.
Right, she did remind us.
Good, okay. I just wanted you to know that she wasn't coming right back.
No, that was meant that she'll be back at some point.
Great. So just a couple of things to report from the department. We are at that time of the year where we are both trying to close things out and also start them up for the new legislative session. So we had our first of 2 hearings before the Joint Budget Committee probably 10 days ago, and this was for half of our department that included the Oil and Gas Conservation Commission to talk about our budget decision items and just sort of our performance. So I just want to maybe publicly thank Wendy Schultz and Mike Leonard and all of their team for their support getting ready for that. The hearing went very well. Lots of good questions, as is usual. Lots of engagement on oil and gas topics. We have our second JBC hearing that covers the remainder of the department, I think after the first of the year, once the new legislature reconvenes. We also have our SMART Act hearing, and I can never remember what SMART stands for, but this is the hearing in which the whole department appears. It's a 2-hour hearing to report on its performance against metrics that were identified in our performance plan and our performance against some strategic policy initiatives. And so that hearing is on Wednesday, this Wednesday afternoon from 1:30 to 3:30. It will be interesting because we will have both outgoing members of the House and the Senate Agriculture and Natural Resources Committees and incoming members of the new General Assembly are welcome to sit in and ask questions and participate actively in that hearing. So we need to figure out how to pitch things at the right level for folks who know a lot about this and have been engaged with the department's work over the last several years, and those for whom this is very new and they might have lots of questions, and we'll find out what's of interest to them. You know, it is also a time of transition. So here we are at the end of the calendar year. So on the Gregorian calendar, it marks the end of that. We're midway through the fiscal year calendar. You see where this is going? Which for businesses and for agencies alike is an important milestone, the fiscal year. And for some of us, our lives are pinned to a political calendar. So for me, more than most within state government, or there's 20 of us within state government in the cabinet, for whom this period of change means a lot personally. So in as much as this may be my very last hearing before hearing as a member of the Oil and Gas Commission, I do want to just take a moment to say thank you to all of you for your service, to the people of Colorado and your service on this commission. You know, they call us public servants because we work for the state, and that means something, but you all are the true servants, giving of your own time and participating here on matters that aren't easy. It takes a lot of work. It takes you away from your day jobs and your families, and so I just want to recognize that and really thank you for the diligence with which you've approached all of these issues, your engagement, your support of the agency, and just all of your work over the years. So from me, from the governor, from the people of the state, thank you for your service on the commission. As far as that goes, we will know more before the end of the year from the incoming governor-elect's team as to who's sitting in this spot, so stay tuned. I will just share that it's been the privilege of a lifetime and the most rewarding and challenging work I've ever been able to do sitting in this role. So I appreciate that as well, and it's been a privilege to serve with all of you. And with that, Mr. Chair, happy to take any questions on what's going on with the General Assembly and any of the department's programs.
Very well. I would have to say that I think the sentiments are mutual with respect to the opportunity to serve with you and as well as Commissioner McGowan and some of the other folks who've been here, Commissioner Walk as well. So much appreciated some of your insights and guidance on matters that we've heard here. So with that, any other questions from any other commissioners? Very well. Mr. Leonard, so this would be from the acting director.
Thank you, Mr. Chair. I'd like to start by congratulating Director Murphy on the birth of her son, Walter Davis. For those of you that don't know, Walter joined Julie's family at 12:49 on November 27th. So, and I will say Julie was here that day at work till mid-afternoon. So with that life-changing event, I sit before you now as the acting director. I only ask that you please be kind for at least the first hour or so. I'll try not to.
Too late for that.
Too late for that. I'll try not to make too many mistakes. I'd like to direct the commission to the staff report for variance requests. There were several in there this time. A couple other highlights from the staff report. The Oil and Gas Commission is now working towards a small unmanned aircraft inspection capability program, or drones. We have 10 staff members that are going to be licensed to fly the drones. They'll be used in the environmental and the inspection and the reclamation groups. They are currently training with some state and local and federal agencies to get this program off the ground. The Flowline Instrument Monitoring Method Work Group continues to work. They've met twice, I believe, and they're going to have a report for you as directed early in March. The Financial Assurance Technical Working Group, and for no better acronym of FATWAG, that report has been posted on the website for your review. Several interesting propositions came out of that for changing the financial assurance rules, and we will have a rulemaking as directed by the executive order prior to September 2019. Also, I believe, in your packet, you'll find a copy of the SOGR idle well review. I believe the engineering group has or will return some questions for the well integrity review. We're waiting on some clarification from SOGR before we release that report. We've had a few staff changes. 3 that are pretty substantial. Sarah Freeman was a permitter here for 7 years and retired. Jim Precup, the Northeast area field inspection supervisor, was here for 13 years. And John Duran, the Raton Basin area inspector, was here for 18 years as an inspector the whole time, and they recently retired. Mr. Precup's position has been backfilled by staff member Adam Craich, and we're looking at backfilling the other opening soon. The last thing I need to report is this is Miss Prine's last hearing. As she has chosen to move on to greener. Well, it's a lot greener in Houston, right? Yeah. Her position will be filled by Miss Mimi Larson.
Well, I like Mimi too. So
that's all I have, unless there's any questions.
Very well. Well, welcome you. Ms. Prine, we will certainly miss you, but we do have capable hands coming in to step into that role. So we welcome Ms. Larson. Be careful what you wished for.
Thank you.
Very well. Any questions, commissioners, of the acting director? Okay. What's next? Since we don't have it here. And we have Ms. Prine's report, your final one.
Yeah. Commissioners, I only have a few things, one of which I was going to gently break the news to Commissioner Overturf that I was leaving, but I am leaving you in very capable hands. Ms. Larson will begin on Wednesday in the role of the manager for the hearings and regulatory affairs. She already knows our department. She knows our people. I think she will not miss a beat for you. So I am just very thankful that we're leaving you in such capable hands. We have had some staff issues in the hearings unit over the last month. First of all, our staff assistant, Marg Humecki, is out on extended leave. That probably didn't impact you much until you noticed the chaotic version in which I tried to get your portfolio up for you. We had several people who split up her responsibilities. We will continue to do that. I'm sad that Hannah is not here. She has really done so much to get prepared for this hearing. And she took on a whole lot of Marg's responsibilities, so I'm very grateful to her. So not only have we lost Marg, but we also lost a hearing officer in the last month who took a job elsewhere. So we have that job posted. We have a list. Ms. Larson will begin interviewing them along with Mr. Rouse later next week or the week after. So because of that, you can see that your consent agenda is a little smaller than usual. It is not as many matters as we would have liked. There are a few reasons for that I will go into in just a second. I did want to give you a sense of our backlog for the hearings unit. We currently have 129 unprotested cases that have not been processed. We also have 110 protested matters. The unprotested cases I am not as concerned about because I know that our hearings officers can get through those, particularly if we hire a new hearings officer to come in. I know that they will get through those for you. The protested matters cause a concern that I think the commission should consider at some point. For every cycle, about 40% of our matters, our applications, are protested. And as you can see from a typical hearing, you hear maybe 3 or 4 protested matters each hearing cycle. So you can do the math on that as well as me. It will take a very long time to get through all the protested matters if we continue using the same process that we use currently. So there are some ideas that the staff have on trying to push these matters along for you, perhaps doing more work on the front end, giving the hearing officer more authority to make decisions so that you are not hearing 2 or 3 hours worth of a protested matter, or to change the dates that the commission meet more dates but fewer times a year, something like that. So I'm leaving that just as something for you to consider as you move along. I don't see protested matters being reduced very quickly. So that's something for you to consider. In this particular hearing, if you had talked to me a week ago, I would have told you that you should expect 2 very, very long days. Then at the end of last week, we had one matter that had cost one of our hearing officers several hours of work to get prepared. They settled at the very last minute. And so that was taken off your agenda. We had another protested matter that took considerable time to prepare for you, where both parties asked for a continuance on Friday, and that fell off your agenda as well. So the good news is that your agenda kind of trimmed down, but the bad news is I lost a hearing officer on both of those matters for almost the entire cycle, dealing with protested cases that now are not in front of you. And we could have spent that time getting consent matters in front of you instead. So I don't really have a solution for those things. I just wanted to make sure the commission was aware that we just ran into some stumbling blocks this cycle. As you heard from a few attorneys, there is a desire for us to try to get some of our own protested matters in front of you. My recommendation is not to hear those matters today or tomorrow, as you have no materials before you, and the hearings unit has not prepared anything for you to review on those. But I leave it up to you to figure out if you would like us to get those prepared. We can do that. We can try to get those done for you sooner than your January scheduled hearing if you would like.
Just a moment. And by that last comment, I'm assuming you're referring to some of the items that came up during the public comment period.
Yes, Mr. Chair.
So typically we've had these come up before. I'm sort of left with the thought that if there was a few things that it would, and so that we didn't force the staff into having to rush around to get them prepared, as there's some time between now and the January hearing that we could schedule a call-in hearing just to do some of these matters and try to get some of these as well as some of those other 129 cases addressed in a special hearing just to address consent agenda items.
Yes, Mr. Chair. Just a side note on that. We are happy to do whatever we can to help move these cases along. A special hearing in between your cycles really sort of jams up the hearings unit a little bit, trying to get things done while we're already on a calendar, because we overlap with all of our cycles. As you know, we are trying to draft orders for this hearing at the same time we're drafting notices for the next hearing. So we are happy to do that. I hesitate to say we would take suggestions on what is the highest priority for the operators, because we have done that in the past and we've heard that everything is a priority. So we're kind of left with trying to figure out on our own what we need to accomplish. We are happy to get matters ready for a special hearing. My request would be that we cap that number so that our hearings unit can continue with their usually scheduled work.
Okay. Commissioners, is this something we'd like to address now? Contemplate, give it some more thought, and come back and revisit it later on during this hearing? Doesn't seem to be a lot of enthusiasm one way or the other at this point. I'm always mindful that there are some matters where there are some things that have come up where there's some of these matters, beyond the scope of the company and through unforeseen issues that have come up with respect to getting items through the consent agenda and staffing issues, that if we can accommodate some of those where the operator does have some deadlines. And I agree with Ms. Prine, it should be a very limited amount so that it doesn't get into the staff's regular matters of trying to get things teed up, that perhaps that might be something that we could entertain. So, Commissioner Overturf.
I will say that, excuse me, my inclination is to follow Ms. Prine's initial suggestion and to not schedule a special hearing. These matters can be continued until the January cycle.
Very well, that's one. Anyone else? Commissioner Hawkins.
Just a question, if we were to try to do them during this hearing cycle, would that be possible or not possible, or like today or tomorrow?
Moment.
Commissioner Hawkins, I don't believe that we have the staff power to get that ready for you by tomorrow.
Okay, thank you.
All right, very well. Mr. Jolly?
I'm just curious what hearing officer we lost.
Mr. Pumphrey, Brandon Pumphrey.
Okay. Just a moment. If we were limited to just the matters that came up, I understand that the SRC matter is that they're okay with continuing that to the next hearing cycle. If we were limited to just the 3 Highpoint matters, and would that be a significant burden on the staff to address those sometime early January, for example?
No, Mr. Chair, I think we could do that.
Okay. Perhaps the hearing officer would have a date in mind to suggest for that.
Mr. Chair, I think given the holidays and the work of trying to get notices out right now, I think we would be looking at sometime after the 4th. Is that the Monday after or the Friday after New Year's? So.
Okay. All right. So a date set to be determined sometime after the 4th. Would that, if we consider that, then I think at this stage, we would entertain either a motion to have that special hearing just to address those matters or not, and then have a vote for the commissioners on that. So certainly entertain a motion. Commissioner Boygan.
Could I just ask, I assume that we could participate by phone?
It will be a telephone participation, yes.
Okay, well then I'll move it that we have the special hearing, consider those matters sometime after January 4th.
Those matters being just the items that were brought forward in the public comment period?
Yes.
Okay, so that motion is made by Commissioner Boygan to hear, I believe it was 3 matters or 3 matters that were brought forward by Highpoint during the public comment period. Is there a second?
Second.
Seconded by Commissioner Hawkins, or I think Commissioner Holden, I think Commissioner Hawkins just snuck in front of you there.
Oh, I was there before you was.
Okay, yeah, it was just the phone lag, I guess that's what it is, probably. All right, very well. Motion made and seconded. Any discussion? Okay, then if we're ready to vote, all in favor say aye. Aye. Opposed, same sign.
No.
Very well. I think the motion carried. So we will count on, I guess this would be up to Ms. Larson at this point to schedule that, to work with the hearing officer and the party to get a time scheduled to do that. All right. Okay, thank you. Yes. Certainly. So I've been asked to clarify for the record the 3 docket numbers.
Yes, Mr. Chair, those are 181200936, 937, and 957.
And that matches what I wrote down, so we're good to go. All right. We're now up to, we've heard our reports, so any other commissioner comments? Commissioner Hawkins.
Just a couple of comments on kind of where we are on the Swan site. I heard some comment today from the public, and I had understood that Conoco had moved that site. Is that, I just want to get some clarification on kind of where we are with that so that I'm clear on it.
Mr. Duranlo?
Good morning, Greg Duranlo, Environmental Manager, COGCC. To the best of my knowledge, ConocoPhillips has resubmitted the application, the Form 2A application for a location at the Swan site as previously submitted and then subsequently rejected by COGCC staff. The rejection was on technical grounds only. And we did expect that they would at some point resubmit that application, and they did so. The application is at that same surface location as previous. So the information that came from public comments this morning with respect to 3 mile laterals and an agreement with a developer was news to me.
Okay. Has staff looked at any alternative siting with Conoco that would be suitable in our opinion, in staff's opinion?
So we have had discussions with Conoco about drilling from the west side of their well bores to the east, which would put the surface location farther from the Watkins Farms subdivision. The surface owner is the same as the currently proposed location, and it was our understanding that the surface owner was opposed to that configuration. Opposed
Okay.
to moving the location to the west. Additionally, we have reviewed some information that would have allowed for drilling from a site further to the east. And I don't know how that was dispatched or what the final outcome of those discussions were. It was on another fee surface owner, I believe severed from the mineral estate.
Okay. And so with the resubmittal of the Form 2A, we're just going, did they make a change or correction to our technical concerns?
The application just came through the completeness process, not last Thursday, but the Thursday prior. I don't believe that staff has completed their technical review as of yet. So it is there and the public comment period is open.
All right, thank you.
The process, by the way, for our rejection process does retain public comments that were made on the original application. So if folks made a comment originally, those comments are still retained as the application goes through.
Good, thank you.
Commissioner Jolly.
Just to follow up on that site, which seems to surface every meeting. If the owner would allow it, the same landowner was to allow it to be moved to the east, isn't it?
The same surface owner owns lands to the west.
To the west?
Yep.
How much further away from the houses does that put it?
So I believe that was proposed with a 1 mile or a 2 mile wellbore lateral. So it would move it to the other end of that wellbore, which would then probably increase the distance to that Watkins Farms neighborhood to about 1.5 miles.
And the other recurring comment is about the secondary access, emergency access with a locked gate. Is that being addressed, or is that acceptable?
I don't have a exact answer for you, but my understanding was that there was a different alternative that had been started to be discussed with the fire protection district and the local government that would control those accesses and easements. But again, that's something that will be part of our review as we go forward on this.
Just to be on the record, we hear the same comment that the people are almost locked in an event of an emergency. They can't get out, or unless somebody unlocks a gate, it sounds like. So it just seems like a glaring concern.
We'll certainly consider that in our review.
Mr. Chair, if I may.
Acting director.
And I'm reaching back in.
Interim director.
Former life. That the gate and the locking of the gate was initiated by the Watkins Bennett Fire Department. It was not ConocoPhillips that put the gate in. And to that note, I'd just like to say, and I know many people may not understand this, but that is to control the evacuation. The last thing you want in an emergency situation like that is self-evacuation because it becomes chaos. And the idea behind locking that gate is the first responders would unlock it and control any needed evacuation.
So now that leaves me with two questions. The first was just to make sure that I heard what Mr. Duranlo said, which is what I heard is that there would be local government and the fire protection district involvement in this discussion with respect to the 2A.
Certainly the local government through the LGD program. The Watkins Bennett Fire Protection District was engaged in the previous, in the discussions we were having with the previous submittal. If our technical review determines that we need to revisit those issues, then we will.
Very well. And then what's missing for me is what you just brought up, that if it was the decision of the Watkins Bennett Fire Protection District to lock that gate for a reasonable reason as far as controlling evacuation in the event of an emergency, why has that not been publicized well enough so that we continually hear this as an upcoming issue? So there's something missing for me here, is that part of this local government involvement is also so that the local residents hear what's going on. And so why is that missing here?
I do believe it was announced through the Arapahoe County process. This alternative road being built. I believe ConocoPhillips is building the road. I'm not sure.
And again, those are the details that I don't have in front of me and am not certain.
Okay.
But I believe this was all addressed in the Arapahoe County process.
Very well. I mean, it leaves me with a significant concern of we're continually trying to work more and more to involve the local governments in these processes, and some of that then making, it doesn't fall on us to ensure dissemination of that information, but it certainly gives me a lot of concern that local governments are not giving that information out to the residents. It's just a comment. I don't need a response from that. So, thank you. Anything else, Commissioner Hawkins?
Well, I did have one other item that I have been thinking about a little bit. I'm not expecting any response necessarily today, but I do know that we continue to hear from local governments that their opportunity for involvement in our hearing process and decision-making process is flawed, that we push them back from spacing hearings to Form 2A processes, and that occasionally they get some input and occasionally they don't. And I don't really know what change we need to put in place here, but I do think that there's some process we need to put into place that provides a very clear opportunity for the local government to participate when we're either spacing and planning to put a well within the proximity of their constituents, their urban areas. They need to be involved as early as possible and not continue to be put off until the well site's already been selected. And basically their opportunity to impact that is pretty much reduced, pretty limited. So I just see a flaw there that it's something we need to take on and try to remedy. I don't know if any of the other commissioners have comments on that.
I have some, but I can wait. Commissioner Boygan.
And maybe I should wait until you make yours, but
I'm happy to make mine first if you like.
I'll jump out there and then you can rebut what I say. So
that's a presumption that I'm going to rebut you.
I'll just pick up a little bit on what Commissioner Hawkins was saying. To me, it's not just a question of process, because there are substantial questions regarding the extent to which surface issues are even relevant. In the Form 2A and Form 2 process, we, as Commissioner Hawkins noted, we tell applicants and we tell protestants and interested parties that surface issues have no place in a drilling and spacing unit application hearing. We tell them to wait until the permit process is underway, and then when the permit process occurs, we sort of tell them that, well, our issues are kind of the downhole issues. There's not a whole lot of authority that we have, for example, to deal with surface impacts, other than if somebody can show that it's a threat to public health, safety, and welfare. And of course, that's in the eye of the beholder to a certain extent. But there's a bit of and this is what I think some of the comments are getting at. There's a bit of a conundrum there, because it's not clear cut whether you see it in Watkins Road or the Boulder County matters, Adams County a few months ago. There's a lot of concern that our process doesn't really fit perfectly with local government process in addressing concerns of citizens about surface impacts. And so I'm not going to propose anything. I'm just, I think, following up. It's more than a question of process in my mind. There are questions, substantive questions about the extent to which our rules currently contemplate dealing with those kinds of issues, number one. And then second, whether they should either in their current form or in some changed form deal more effectively with those issues. So to me, it's more than just a process question.
Fair enough. And I think I was thinking of two things. One, I know, and I'm not sure if this addresses it to some extent, but we're working on a informational brochure on pooling and what local governments can do, what residents can do with respect to pooling applications. And I'm not sure if that's published on our website yet or not. And does it provide a little bit more scope around here's where you can interact with the commission with respect to rules and with respect to pooling and spacing applications and where you can get involved?
Mr. Chair, the final version of that pooling pamphlet was included in your portfolio. Yes, it does address the point at which you can insert yourself into the process and what happens if you don't sort of get involved in the process. It does not specifically refer to local governments and how they can become involved. It is more aimed at citizens who receive an offer letter from an operator and they're not quite sure what they're reading. That was sort of the aim of the statute that required us to send the pamphlet in the first place. If the commission would like us to add a section specific to local governments, I think we could accommodate that.
It might be useful. You pointed out that there was one thing that I didn't get a chance to read, and that's quite all right. I deserve it. Secondly, the other thing I'm left with, and I think Commissioner Holton is online here. It seems like we have an example of a county that's had to deal with this on a regular basis in a local government. Weld County, I think, is either the most active or one of the most active counties in the entire country for a number of active wells. And clearly this, they're not here on a regular basis. So somehow they've figured out how to make this work. So I'm wondering, can we draw on some of that expertise within Weld County, either within the the towns, the county, however that may be, to help us out with providing that understanding. So here are the issues and here's how we've resolved those. And perhaps that could be something that could get onto the OGCC website in some form. So Commissioner Holton, anything that you can add to that would be much appreciated.
You know, the city of Fort Lupton, we've had no problems with that. You have to have a strong LGD. And we get letters from the Oil and Gas Commission all the time saying this is what's going on. We've got a permitting process within the city limits. We've worked really well with operators that they fix our roads, and that's probably our main issue is the roads. But I don't see a problem with our process right now. So if anybody's not getting involved, then they need to get involved. They need to get their LGD involved. They need to look at that paperwork. We do it every day. Every day we get something from Oil and Gas Commission. So I don't see a problem with the process right now at all.
So your process is working. Is that something that's available publicly through the city of Fort Lupton's?
Absolutely.
So
I mean, every time that there's permits going around town or in the city limits, which I've got probably, I don't know, 250 wells within the city of Fort Lupton. When they drill within the city of Fort Lupton, they've got to come in for a special use permit. And that's noticed. It's in the paper. It's on our website, everything. And on the outside of the city limits, the Weld County Commissioners are very good about letting us know what's going on. And we always tell the operators, do not come in here and just do something. You need to come and you need to communicate up front first. And so that's the big thing, is communication with the operators. It's not just start a fist fight, you know, the minute you hear about it. It's getting with them before then.
So when you think about, for instance, this Swan site, which impacts the local community and as well as, I'm not sure if there's a county or a municipality that's involved in this, but clearly the Watkins Farms folks are involved. How do we, or is it possible for us as an Oil and Gas Commission to provide more insight into how Weld County works and how Fort Lupton works, so that lessons learned from that can be adopted by other municipalities, counties, local governments to assist them in making sure that the operator gets in front of them early on in the process and get some of these issues addressed? Because it works for you.
Oh, yeah. I mean, just around my house, my personal home, there's probably 60 wells that they just finished drilling in the last 6 months. So, but they came in and they talked to us. You got to engage the operators. And that's part of what local government's supposed to do. And like I said, if it's not within the city limits, then we work really close with the county and we work through those issues there. Because some of these wells that are next to my house are in the county. But guess what? They've got to drive across the city of Fort Lupton Road. So they better come in and have a little discussion with us to see how they're going to repair the roads or how they're going to operate. So, I mean, we're engaged every day. So unless you just don't want oil wells at all, there's no reason why you can't get involved.
Okay. I mean, I don't think we're going to be able to come to any closure on this, but I would ask to leave it with the incoming hearings manager to maybe do something that we could add to our pamphlet on pooling that would provide links to some of these counties that do have they've come up with a solution that works for them. And that provides some insight into some other folks, because it seems like there's been a lot done in both Fort Lupton, probably some of the other municipalities within Weld County. There's been a lot done there to resolve some of these issues that keep coming up elsewhere. And if we can borrow on that, it would probably benefit some of the other areas that are now seeing an increased level of development.
Well, yes, part of the problem too there is that some of the information that the public is getting is so complicated and it's in legal jargon that they can't understand. And probably most of the phone calls that I get, you know, on my cell phone or my personal phone or at the city is because people don't understand what's going on, because everything is so complicated that they can't read it. I mean, it needs to be simplified. That would be my biggest suggestion.
Very well. Commissioner Hager.
I think simplification certainly goes a long way. I think also what I heard in public comment is not just local government struggling, but the public, the general public struggling to participate. And I think that we can something we can do relatively quickly. And we tried to, I think it was repeated a couple times today about what's public or what's part of the record and what's not. And but people who come here think that they're making a difference. They're trying to make a difference. And for Boulder to tell us that then when they take it to district court, none of those public comments are even admissible, that makes people feel like they weren't heard, even if we heard them here, sitting here. And so maybe if we can clarify, have some more clarification on what that means to give people opportunity to come and actually be on the record if they want to, recognize it takes more of their time, and they'll probably have to sit here and be cross-examined if necessary. I think that's important, and it's something that we might be able to clarify sooner in writing when people try to sign up online. And then the other thing is that I think we've seen what Commissioner Hawkins was saying and what Commissioner Boygan were saying about these downhole issues. And we say it's downhole, we're not talking about surface. Go to the Form 2A. But we see operators more often submitting Form 2s and 2As all the time. It doesn't necessarily mean that pooling application or that joint spacing order is the first thing that happens. And so people are catching the Form 2 and 2As too late. And then when they're in an adjacent community or local government, they don't get notice. And so there's a lot of complications that have to be simplified and that have to be considered in the future.
Fair enough. Commissioner Overturf.
I wanted to just follow up and say that I agree with the comments of Commissioners Hawkins and Boygan. And I was going to say similar to you, Commissioner Ager, that I think one of the other complicating factors is that there's a lot of irregularity in the way that these things proceed. There's not kind of a set order. First, you get a spacing order, then you get a pooling order, then you get they seem to happen at whatever kind of time frame the operators want them to proceed. And so I think having some additional structure around that process could be really helpful in having, in addition to the good comments that were already made by other commissioners, into having members of the public better understand how the process works and where they can and should engage. And then I also wanted to follow up on the comment by Commissioner Ager and some of the public comment that we had today about public comments. And I could be wrong, but I'm not aware of other state boards or commissions like this that require public comment to be submitted under oath and subject to cross-examination. And I wonder if we have more rigorous requirements on public comment than may be necessary. Other state agencies that I have practiced in front of in my day life have a system where oral comments can be made at a public comment hearing or some other forum where they're transcribed and so can be placed into sort of a written form, but can also be submitted in writing all the time and are made part of the administrative record ultimately on appeal. And so I would be curious if we could, if perhaps an email could go around the AG's office or something to just get a sense of how other state agencies handle public comments. Because if our processes are more restrictive than other state agencies, that would cause me to want to look at the rules that we do have and see if, again, we're putting up roadblocks that are really unnecessary.
Well, Commissioner Randall.
Thank you. Commissioner Overturf, I think that's a great suggestion, and getting some context for the commission's rule would be helpful. If that research is undertaken, I think it'd be important to look at circumstances where the agency is acting in an adjudicatory manner versus legislative, and sort of what the effect of that record is before both the entity making the decisions and also by a reviewing court. Because I think my understanding, just from looking at some of the pleadings in the case, is that the rule that the commission has, which has been in place for 20 years, is limited to adjudicatory matters. And so, again, I just think that context should be present, because I don't know if other agencies, how they behave in that posture.
May I respond?
Yes, Commissioner Overturf.
I think that's completely right. And I think having that distinction is really important. I think that there are ways, even in adjudicatory proceedings, where you can have things that are in the record that are not necessarily evidence. And so understanding that distinction, I think, is also important, even in an adjudicatory setting. Sorry to give you work, Kyle.
Well, and I was going to actually ask Mr. Davenport if he could give us a little bit of clarification, because there's been some discussion about this. And to me, it's a fairly simplistic way to look at it, that if it's something that we want to be in the record as part of a hearing matter, then it needs to be factual in its nature, where public comments, we don't necessarily put that bar on them. And so perhaps maybe some clarification around that. So Mr. Davenport, if you could correct me.
Well, I don't think you need correction on anything, but I'll do my best to clarify.
Great.
I'll try to give an overview of this. So this agency accepts public comment at the beginning of its meetings. And that public comment, obviously, people aren't sworn in. They're not subject to cross-examination. But the public comment that are given at the beginning of these meetings are not put into the record for a particular matter that this commission hears later in the day or the next day. Rulemaking is different. When there's public comment for rulemaking, that does go into the record. But for an adjudicatory matter, in order for it to be included in the record, Rule 510 provides that that person must be at that hearing. They must be sworn in. They must be subject to cross-examination. And the parties to that adjudicatory matter have an opportunity to object to the inclusion of that 510 statement into the record. And that recognizes a few of the important due process rights that parties to adjudicatory matters have. And so that's the distinction. Is the question is, I think Commissioner Overturf has raised, is how do we treat those public comments at the beginning of meetings? If a public commenter has an objection to oil and gas in general development in this state, that doesn't go into the record for every matter in which this commission hears spacing applications or whatever else. And so I think 510 is clear in that regard, isn't it? Or what needs to be considered or what needs to happen before a 510 statement can go into the record for an adjudicatory hearing. And I think that's all I've got. Does that answer your question, Mr. Chair?
I think so. So to put it into context, is that general comments made today, not necessarily with respect to any specific matter, those are just general comments, don't go into the record. However, tomorrow we're going to hear public comment on rulemaking, and those will be part of the record. Okay, very well. Commissioner Boygan.
Mr. Chair, I just want to point out the obvious, that for the Form 2 and 2A process, there is a public comment, separate public comment procedure built into the rules, which is supposed to generate public comments that are then taken into account by staff. I think part of what we're hearing is that interested parties are not always aware that those Form 2 and 2As have been filed, and so they have some concerns about that. And then there's the question that we've kind of already touched on, which is, even if the public comments are made, to what extent does the commission actually have authority to address some of those comments when they deal with, for lack of a better term, land use type impacts or surface impacts? And that's an ongoing sort of wrestling match that's, I think, unresolved. Although I think I have a pretty good idea of what staff thinks in that regard. So there is a process that's theoretically aimed at providing a mechanism for public comment on those kinds of permits. It just may not be working as well as it should be.
Just a second, please. Yes.
Thank you, Mr. Chair. I just want to follow up on Commissioner Boygan's comment in raising public comments to permits. Those are in the record. Right. Just to clarify, those, if a person submits a written public comment to a permit application, those are in the record.
If you do it in time, if you meet the deadline under the rule, which I think is 20 days.
It's 20 days unless the LGD asks to extend. And then there are some other time frames that are longer for large urban mitigation areas.
Right, and that was what I was going to bring up is some of the, particularly around here on the Front Range, there's more and more of these are the large urban mitigation area, in which case that comment period gets extended. Or to go back to what Commissioner Holton said, having an LGD that's active can potentially also provide more of an opportunity for residents, not just local governments, to get involved in the process and make their concerns heard. So, any other commissioner comments? I'm watching. We are on a time, Commissioner Hawkins, so keep that in mind.
This is, I'll make short, brief. Last hearing, I made a comment about that maybe the commission should consider a basin-wide spacing order for the DJ Basin for horizontal wells. And there wasn't any response or comment, or, you know, it was kind of just dropped like a drop the mic and oh. But I do think that based on my experience, probably half of the hearings that we consider and that the staff considers are spacing hearings for the DJ Basin, or on that order of magnitude. And in Colorado and other states, it's not uncommon to establish a basin-wide spacing order that would pretty much eliminate most of those individual applications. Not to say that there couldn't be a request by operator to ask for a different size spacing unit for certain reasons, but it could definitely start to streamline some of our process. Could be beneficial, and then maybe some of the operators would like that as well. If we were to kind of standardize a 640 or a 1280 or accommodate some kind of standard spacing in the DJ Basin. And I think it's an idea that's we should consider in some fashion, maybe get staff's input on whether they think it would be beneficial. Just throwing that out there again.
Thank you. I think it's worth investigating. I think I would very much like to hear what operators have to say. Because I guess my concern would be is if we establish that, then we have an equal number of applications to have a variance to that spacing order that we currently have for the spacing orders. So it's certainly worth investigating, but perhaps the first step would be our engineering staff to have some discussions with some of the active operators to see what their thoughts are around that before we undertake another rule making. So
that's a good idea.
Any other comments? Thank you for keeping us almost on track. I think at the next, we have approval of the minutes is our next agenda item. Commissioner Boygan, would you like to approve the minutes?
You're assuming I have comments on the minutes?
Well, I'm laying on.
I actually did read the minutes and I have no comments. I'll move that they be approved.
Yeah. So so Commissioner Boygan's moved approval. Is there a second?
Second.
Seconded by Commissioner Ager. All in favor, say aye. Aye. The minutes are approved. Thank you very much. We are now on to the consent agenda items, which we usually start with any conflicts with any of the commissioners with any of the items. And then we also have one other item we need to address after we talk about conflicts. Go ahead, Commissioner Boygan.
Sure. I'm going to recuse myself from several matters in which Extraction or its affiliates are involved on the consent agenda. And so in Group A, I believe there's one Extraction matter. In Group E, there are 2 8 North matters. And in Group F, I think they're all Extraction matters. So I'm going to recuse myself from those matters.
Okay, I suppose we probably should obtain this particular docket numbers for each of those. So would you be able to provide those, or do you want us to go look through and pull them out?
I can do that, Mr. Chair.
Okay. Ms. Prime? Let's make sure we read them into the record, though.
From Group A, I have docket number 180600437. In Group E, 180900636, 180900637. And then Group F, 180600435, 180600438, 180600450, and 180600460. I believe that's all I have for extraction or 8 North. Is that right?
Is that for you, Commissioner Wiggin? Okay. And I think we also, there may be a couple of those that are also affected by the next matter. Would you like to introduce that, please?
Yes, Mr. Chair. We were requested by Attorney John Jennings to approach and speak to you about 2 of the consent matters. He is the attorney for the Larsons. That matter with extraction, you'll be hearing it after lunch. But Mr. Jennings and Mr. Rittenhouse would like to approach and speak to you just for a minute about 2 of our consent matters.
Please come forward. All right, who'd like to speak?
Mr. Chair, before, I'm sorry.
Mr. Wiggin.
If this has anything to do with the Larson matter, I'm going to be recusing myself from that matter as well this afternoon. So I guess I can still sit here, but I'm not going to participate.
I'll make sure not to ask you to make a motion then.
You'll have to hold me down when I help myself.
If you can't help yourself.
I want to, just to be clear, I'm not participating.
We'll leave that to Commissioner Hawkins to keep in line.
Take the mic away.
Very well.
So at the forefront, Joby Rittenhouse, Beatty, and Wozniak, I'm here on behalf of Extraction. I want to make it clear that Extraction did not request this additional time to bring this to your attention. And in fact, Extraction would object to this additional time to go toward this. In these 2 matters that are before you or that will be discussed, and these are docket numbers 180600435 and 438. These matters are currently uncontested. The Larsons and counsel for Larsons were specifically instructed to address these issues during public comment. They chose not to. The Larsons have not filed any motion for reconsideration or any formal filing with the commission, and therefore I object to the request before you. And to that end, I'd like to address the merits of the argument after the fact, if need be.
If need be. Go ahead.
Good morning, Commissioners. Thank you for hearing this request. Larson, my name is John Jennings on behalf of Larson Front Range Farms, Donna and Ivar Larson. Donna and Ivar are here today in the audience. As Mr. Rittenhouse mentioned, you're going to hear a case between Larson and Extraction this afternoon, starting at 1 p.m. We hope our request here on the consent agenda is relatively straightforward. In Group F, there are currently 2 dockets listed with Extraction and with Larson as party. We are just going to ask the commission to hear those matters this afternoon. They are in fact contested. These matters have been going on since approximately April 2018, and there's been a lot of legal work done, investigation, factual issues that these parties have talked about, and we believe hearing them now on the consent agenda with the dozens of other matters before you would not be appropriate, and so we ask for the opportunity to address those 2 dockets this afternoon. As Mr. Rittenhouse mentioned, these parties came together for a final pre-hearing conference on December 4th, and this issue was specifically addressed. The hearing officer made it clear that Larson could request the removal of these consent agenda items, and so Larson would be happy to get into the the facts and the legal issues here, or we'd be happy to do so this afternoon when you hear from the same parties about the same issues, essentially, including these two dockets.
Mr. Rittenhouse, can you summarize in sort of a short way your concerns?
Yes, my concerns are, I think, twofold. First of all, the procedural impropriety of this type of approach. The hearing officer specifically stated that to the extent there were issues that Larson's wanted to pull this off the consent agenda, that time was allotted for public comment and the time restrictions there. They chose not to do that. If I can jump off some of the comments Ms. Prine mentioned during the secretary's report, the concerns before you are that you are being required to allot a significant amount of time toward contested matters. And now here we are before you attempting to address what is an uncontested matter that is on the consent agenda. There was a protest against both of these dockets at one point in time. That protest has been dismissed. The Larsons don't own an interest in these application lands. That was the basis for the dismissal, and therefore extraction would simply the request that you uphold and support the decision of the hearing officer in these matters and permit these two docket numbers to proceed on the consent agenda.
Very well. Commissioner Overturf.
What was the deadline for motions or other pleadings in this matter?
I don't recall a specific date. There was a deadline for any motions that has passed. Larson's did not file a motion.
And so I just wanted to confirm with counsel for Larson's. I apologize, I don't recall your name, but did you file a motion for reconsideration or anything challenging the hearing officer's decision?
Excuse me, we did not. These two particular dockets have been part of a series of cases that have been going on, like I mentioned, since April. And so essentially we've got two of those pulled off the contested agenda and moved to the consent. That was done by a order of dismissal issued by hearing officer Rouse. That was in early November. As of November 14th, in this current matter, we had a case management order entered that included all of the contested dockets. We discussed this specifically on December 4th before the hearing officer that Larson did want the full commission to hear these issues. So to answer your question, we didn't file a motion. We didn't think it was necessary. These dockets have been included in the entered case management order, and we agree that there's a hearing officer order dismissing the objections. All we're asking for the commission to do is review that and hear the facts and issues this afternoon.
Care to comment, Commissioner Overturf?
I have comments, but I don't have any further questions.
Okay. So I'll struggle through this not being an attorney. So I was sort of left with these two get pulled, they get thrown into the hearing matter this afternoon. So we essentially hear the same thing and the same amount of allotted time with just two more docket numbers thrown in. Would that be appropriate to say on your side?
That's our position, yes.
Mr. Rittenhouse.
And I would disagree. The basis for the dismissal creates a brand new issue that would have to be interjected into that hearing. The issue with regard to these two dockets is whether or not Larson's has standing to bring a protest against these two applications. That is not at issue with any of the other dockets that you will hear this afternoon.
And it's my understanding they were dismissed on the basis that Larson's don't have standing? That's put in the consent agenda?
By and large, yes.
Very well. Commissioners, I would ask if I could get some potential input here from either one of our attorneys on some direction.
Well, since Commissioner Boygan.
Well, actually, we have more than
That's
two,
true.
but that's true. Sorry, Commissioner Randall, I forgot. No.
I
Commissioner Overturf.
would recommend that we reject this request. I think the appropriate time to make it would have been to file exceptions to the hearing officer's order, alleging that the hearing officer's order was in error. They failed to timely do that. And I think raising it now without actually presenting any argument about why the determination that standing was lacking was in error, that this is untimely and inappropriate.
Very well. Mr. Davenport.
Thank you, Mr. Chair. apologize for interrupting, but I feel compelled to clarify the process here. These matters are on the consent agenda, and pursuant to Rule 520, the way this goes out is if any commissioner feels like they need to be removed from the consent agenda, they may do that on their own. No motion is necessary. If they are removed from the consent agenda, then they can be heard later, but the rule provides only if practicable and agreeable to the applicant. So the issue is right now, each commissioner needs to decide if they want to remove this from the consent agenda. If it's removed from the consent agenda, these will be heard later.
Right, but it's not a commissioner making the request, it's a party. To me, that's fundamentally different. That this is a party asking us to take something off the consent agenda, not one of the commissioners.
I agree with you that a party is asking for, but any commissioner may, pursuant to the request, now remove them from the consent agenda. You do not need a motion and a majority approval to remove them from the consent agenda.
So does so basically, then what I heard is that essentially there has to be consensus amongst all the commissioners that we either are or are not going to remove those. Is that correct?
Any commissioner can just type up and say, I want this off the consent.
That's just what I said, just a different way.
Okay,
yeah. So perhaps we can make this straightforward, unless Commissioner Boygan, would you have anything you'd like to add? Or Commissioner Randall with comments? Okay.
Commissioner Boygan is recused.
Okay. Oh, that's right. No, I'm not. Sorry. Thank you. Thanks, Commissioner Hawkins, for keeping him in line and for abiding by my forgetfulness. Very well. Other than Commissioner Boygan, are there any commissioners that would like to have these, that would request to have these removed from the consent agenda? Hearing none, I presume that they will then stay on the consent agenda. Very well. Thank you, gentlemen.
Thank you.
With that, let's get back to the consent agenda items. And what we are going to entertain a motion on is everything in consent agenda items group A through J, with the exception of 1806-00437, 1809-00636, 637, 1806-00435, 438, 450, and 460. Does that match what you have, Ms. Bryan?
It does, Mr. Chair.
Okay, very well. Is there a motion?
So moved.
Moved by Commissioner Hawkins to approve those items on the consent agenda. And, oh, Commissioner Holton, sorry. All right, would you like to second Commissioner Hawkins?
Sure. Second.
Seconded. Sorry, go ahead.
You keep putting Hawkins in front of me. Oh, what's going on with that?
Okay, there probably is some advantage to being in the room. So, but he did say that you made the motion and Commissioner Hawkins has seconded that motion to approve those items on the consent agenda with the exception of those items listed. So that means that Commissioner Boygan gets to participate. All in favor say aye. Aye. Opposed, same sign. The items are approved. Now, with the exception of Commissioner Boygan, who has recused himself, we will entertain a motion for, do we need to read those again? Or is the record sufficient to say that 1, 2, 3, 7 items?
I'm happy to read them over again.
Let's read them
be clear.
just to make sure. Yes.
So the current vote would be for 1806-00437, 1809-00636, 1809-00637, 1806-00435, 1806-00438, 1806-00450, 1806-00460.
Very well. Is there a motion?
I'll move to approve those items.
All right. The motion made by Commissioner Hawkins to approve those items. Commissioner Holton?
Second.
Seconded by Commissioner Holton. All in favor, please signify by saying aye. Aye. Motion carries. Thank you very much. I believe the next item is, Brian, I think, is our enforcement orders by consent.
Yes, Mr. Chair. In Group A of enforcement, you have docket numbers 1812-00504, 1812-00375, 1810-00657, 1809-00501, and 1809-00016. Enforcement staff is here if you have any questions.
Very well. First, is there any conflicts amongst the commissioners? Hearing none, are there any items that commissioners would like to remove from the consent agenda for additional discussion? No. Or ask questions, sorry. Ask questions. Sorry, I didn't mean to jump that far. Anyone? Yes. Commissioner Overturf.
I do have some questions about 501, the Cub Creek matter.
Very well. Any others? Commissioner Boygan?
Yes, I have some questions also about that matter and also about Alta Mesa and Lawrence.
Okay, so perhaps we go in order. Let's start with Lawrence, which is 1810.
Oh, that's
00657, third down in the list. At least on the agenda, it's third on the list. Then Cub Creek, then Alta Mesa.
Okay, so my question, Mr. Chair, was I wasn't clear on why staff is suspending most of this fine. The sense that I got in reading the materials was it's because Lawrence is leaving the state, not because of the merits. It may be an issue of collectability. I'm just not clear, so I'd like an explanation from staff.
Good afternoon, Commissioner. I guess it is afternoon now. This is Steve Kirshner. I'm enforcement officer. I worked on this case. Also present is Dave Neslin for Lawrence Oil and Gas. So your first instinct is essentially correct. The penalty assessed in this case was significant, and staff chose to resolve this case with the cash penalty of $100,000 and the additional remedies as laid out in the order. In part in consideration of the fact that Lawrence was willing to wind up its oil and gas operations in the state, proactively plug and abandon its wells, and begin reclamation of its locations. We've seen a number of situations come before the commission, especially over the past year, where you've had smaller operators who have essentially fled the state, leaving the state and the people of Colorado with the liability for cleaning up, plugging those wells. Where you have a situation with a smaller operator facing a significant amount of penalty liability, staff felt that a resolution like this is the preferable option to an operator leaving the state and essentially leaving us with the bag. So to update the commission on the situation as it stands now, in the AOC, it's contemplated that Lawrence would plug those wells and begin reclamation. As of late last week, Lawrence has plugged all of its wells in Colorado. Reclamation has begun at those locations. Staff is also, as part of this order, collecting a sufficient amount of additional bonding in order to reclaim every location in the state. So basically what this order would do is wind up Lawrence's operations to the point that the state would not in any circumstance be left with liability. Though the amount of the suspension is significant, you still have a significant cash penalty here to operate as a deterrent for operators to sort of fail to comply with field inspection rules. So staff felt that given the mix here, and especially considering Lawrence's willingness to work with staff in winding up its operations and plugging and abandoning these wells, staff felt that this resolution was appropriate.
Mr. Chair, just a quick follow-up. That answers most of my questions. Because I was concerned about the follow-up. What happens if they don't? Apparently they've already plugged the wells, and then there was a cash payment they were going to make, and I'm assuming they've already made it?
No, Commissioner. The payment would be contingent on the commission approving the order. So the cash penalty in this case is $100,000, and that would be due, I believe, 35 days after the commission mails the order.
Right, because to me, the obvious question is, so what happens if they don't perform? But
So
seems
if,
like that's largely almost moot.
I would agree with that.
Mr. Neslin.
Yes, if I could briefly add to what Mr. Kirschner had to say, the total sanction here is a $100,000 cash penalty, which will be paid within the next 30 days. The plugging of the wells, which as a practical matter will cost about another $100,000. An increase of bond amount from $60,000 to $110,000, which is the amount that the staff determined would be sufficient to ensure completion of the reclamation at the site, which is essentially just revegetation. It's a flat site in eastern Colorado. So the total out of pocket to the operator is about $250,000, of which maybe they'll get $50,000 back when reclamation is completed and the bond is released, if that is in fact what happens. That's a substantial penalty. There were a number of violations here, but no allegation of environmental harm. And the operator has wound up its operations and will be departing the state. We believe it's a good result for both sides and a good resolution to this matter.
All right.
I'm good.
Satisfied? Okay. Commissioner Overturf on Cub Creek would be the next matter. You said you had some questions on that, and also Commissioner Boygan.
Yes, so I have a couple of different questions, 3 actually. So I'm on page 5 of 11 of the document that was in our portfolio. And it says that staff found independent factual bases to support violations of both rules 912A and B, but that nonetheless you consolidated these violations for purposes of calculating the penalty.
It's correct.
Can you explain why?
I can. So there were kind of multiple reasons that went into this. Let me back up and say sort of the essential problem that we had here is one that the commission discussed earlier this morning in the Triple Creek situation, is that operators are facing a loss of gathering capacity, and operators are choosing to handle that in different ways. In this instance, obviously you have another operator who chose to flare a large amount of gas when faced with that line capacity issue. What Cub Creek really failed to do in this instance is to consult with staff and to notify staff via those Form 4s beforehand. Had Cub Creek done that, staff could have come to the table, possibly approved either some form of this flaring or the flaring as it was conducted at the sites, but Cub Creek failed to do that. And in light of that, staff only found out after the fact. So when viewing it through that lens, staff felt like the amount of gas that was flared was excessive. But as I said, in speaking with engineering staff, if Cub Creek had come to us beforehand, filed the Form 4, consulted with staff, and worked proactively with staff to address the situation, it's likely that staff would have approved this flaring at these sites. So that was taken into account as far as consolidating those for penalty purposes. Another thing that was taken into account is that staff has combined these before. Staff's done a unified 912 violation before in Order 589. So those were taken into account as well. Ultimately, staff felt like had Cub Creek come to us before conducting these flaring operations, we wouldn't be in the situation we're in today. And staff felt that given that it was appropriate, not only for those reasons, but also just to make the penalty sort of more closely fit the nature of the violations, to combine those in the violations for both pads.
Okay. And then you also say that you classify the violation of Rule 912 as Class 2 minor impact, and you state that the flaring was conducted using an emission control device, and therefore it resulted in minimal actual adverse impact. But when you look at what the sort of classification of how these are supposed to operate, that minor is supposed to be no actual adverse impact. So I'm having a hard time understanding how you can justify classifying this as minor, given that there was an actual impact.
That's a reasonable consideration, Commissioner. I think that first it's important to think about The commission's approved this reclassification before at least 4 times, and we have order numbers that we looked at in making this decision. The thing that staff really looked at when determining whether or not to reclassify this for penalty purposes was whether we had a flaring violation versus a venting violation. In the case where you're venting gas directly to atmosphere, obviously you have a significant environmental impact from venting gas directly to atmosphere. When you have an operator who's flaring this gas using equipment that's generally approved for this kind of use, you have a destruction efficiency either of 95% or 98%. So you have a much smaller environmental impact. Now, to your point, obviously, it doesn't mean there's no environmental impact. However, given the precedent that staff observed 4 more times, and in a desire to sort of keep this consistent with that precedent, staff felt like in this instance it was appropriate to continue reclassifying that as minor where you had an operator choosing to flare instead of vent that gas.
Okay, and then also on page 8 of 11, it says the Commission's enforcement guidance and penalty policy classifies Rule 912 as a Class 3 rule. However, staff reclassified Rule 912 as a Class 2 rule for the purposes of this penalty calculation. That's incredibly surprising to me, given that I have typically seen staff exercise a great deal of reverence for the enforcement guidance. So again, can you help me understand that?
Agreed, and generally we do, and I think this doesn't change that. I can give you the order numbers that we considered in making this decision, but this is sort of a precedential decision. When we've had operators flaring without approval, this is the way we've generally handled it in reclassifying it from 3 to 2. So we looked back at 4 kind of similarly situated operators who made the decision to flare, and in those instances we have reclassified it to a 2. Staff felt that it was important to be consistent with that precedent in doing so.
Okay, I have a great deal of comments about this, but I will let the other commissioners ask their questions.
Mr. Boygan.
Thank you, Mr. Chair. My comments are sort of in the same vein, but I'll take a slightly different tack. I'm having trouble understanding what's the difference between this situation and the Triple Creek situation that we discussed earlier, where from the materials that were submitted, there was not a Form 4 or advance notice provided, and apparently no enforcement action. Here, for some reason, not apparent to me, Cub Creek is being hit with an NOAV for substantial or excessive flaring. I don't know what the test is for excessive flaring. Why is this excessive and what they did before was not? It's not stated to be just because they didn't file the form. Sounds to me like it's not really excessive flaring and that there is no test for excessive flaring. And I don't know what that means. And so I'm just struggling with the whole concept of what's permissible and what isn't. The thing that I was concerned about was there were a number of incidents which prompted calls to the fire rescue district, and to the point where they stopped coming out, which says to me that there ought to be communication with those local fire districts, because the last thing you want is the fire district to be ignoring calls to a well site because it's the boy crying wolf, right? They got so many calls about flaring that they're just ignoring the calls. So clearly the communication aspect of this was a problem. And apparently they went for a pretty extended period of flaring in 2017, a lot of gas. And I guess that's the test that you're applying, but I'm really confused about what's a violation and what isn't in regard to flaring.
So unfortunately, I'm going to have to punt just a bit on the Triple Creek situation because I'm not familiar with the specific facts of that case. With regards to this case, enforcement staff makes the decision once something's referred over from engineering or from field. So once we receive those inspection reports or those notifications from our various units, then we independently make the decision as far as how we're going to pursue it. To comment on Triple Creek would be getting a little bit ahead of my skis because I just don't know the facts.
Mr. Chair?
Yes, Commissioner Holton.
This is starting to sound more like a hearing. I think we need to pull it from the consent.
I'm listening, Mr. Leonard.
One distinction between the Triple Creek situation and the Cub Creek situation is Triple Creek was in flowback. And there's an exemption in the rule for flowback. Cub Creek was in production. for several months. And the issue with the responding agencies, it was not the local fire department that was not showing up. It was their mutual aid partners that were automatically called. These were called out as structure fires. Excuse me. When that happens, Loveland and Berthoud is automatically called. They just said, we're not going anymore. We did have a conversation with Cub Creek, and they did notify, they did start notifying the dispatch, but there was some confusion there as well. And that information was not always relayed promptly by dispatch.
Okay.
Chairman, if I may.
Yes, go ahead.
One thing that might help is I could ask Stuart Ellsworth to come up and discuss sort of how we evaluate these flaring amounts, if that would help Commissioner Boykin.
We may. I think I see our attorney has pulled out his book. Is there anything you want to add to this? All right. Okay. So my understanding, though, is that if this would be similar to the previous discussion we had, if one of the commissioners wishes to take this off the consent agenda item, we could do so at this time, which I believe then at that point it would go to an enforcement hearing matter. Would that be correct?
Yes, the intent of the rule is if there's any commissioner who wants to have more information, wants to hear from both parties, has more than just simply some informational questions, it is set over for a hearing at a later time, which would obviously be more time consuming than just simply asking your questions now and then being ready. But the rule does provide that any commissioner may pull something off the consent agenda. At that point, it's up to the applicant, in this case, that would be staff, of whether or not to have this for a hearing later in the agenda or to be heard at a different hearing. So the distinction is if a commissioner just needs information, they're certainly welcome to ask that for that information without pulling anything off the consent agenda. If any commissioner feels like they need to they need a discussion, they potentially want to revise or amend that AOC or direct the parties to do it, then that needs to be set over for hearing later and should be pulled off the consent agenda.
Well, so Commissioner Holton, before we go down that path, would it be beneficial to hear from Mr. Ellsworth?
It sounds like Commissioner Overturf and Boykin have issues with this case. And I mean, this is starting to sound more like a hearing item than it is a consent agenda. I think we should just pull it off the consent and have a hearing.
May I respond, Mr. Chair?
Yes, Commissioner Overturf, go ahead.
I will say that I do not think that this AOC is a reasonable penalty amount, and I have concerns with the way that the penalty was calculated. I don't feel bound by the former precedents that we have used in other circumstances for similar violations. That being said, I'm prepared to vote no on this particular consent agenda item. If there's a majority of the commissioners that also vote no, then my understanding is that then staff would go back and negotiate a new settlement with that party. This settlement would be rejected. Given that there's not even a representative from Cub Creek here today, I'm not sure that this is something that the parties would be prepared to go to hearing on.
Commissioner Overturf, they're actually, Cub Creek is actually present today with council.
Okay. But nobody wants to go to a hearing, right?
Commissioner Boykin, help me out. Where are you on this matter?
Well, I think my issue is more the struggle with the whole flaring issue and having a clear picture of what's a violation and what isn't. I understand that apparently the concern here is more focused on the failure to notify. Director Leonard pointed out that it was a production situation, not a flowback situation, which apparently means that they don't, in the flowback situation, there is not a comparable obligation to notify. So I guess I can't say that this proposed AOC is objectionable, is good or bad. I guess I'm prepared to go with staff's recommendation on it. But I think there needs to be more clarity around the whole issue of flaring and what's permissible and what isn't.
John would agree with that.
Mr. Chairman.
Interim / acting director Leonard.
The notice requirement is still in place. The distinction I was trying to make was there's a difference between production flaring and reporting, and flowback flaring, or requesting permission to flare during production, or in flowback, you don't have to request permission to flare.
So you have to make the difference being is they failed to notice that they were flaring during production.
That's correct.
Very well. Commissioner Overturf.
My recommendation would be that we simply vote on this matter separate from the other enforcement consent agenda items.
That's where we were headed. So I think we will do that, but I believe there's one more that I think Commissioner Boygan wanted to chat about before we get to that stage. Am I correct in that?
Yeah, but we've got Cub Creek here. I think we ought to.
All right. So let's go ahead and at this point, let's pull this one out and entertain a motion to, I guess it would be a motion to go ahead and approve the enforcement matter for Cub Creek Energy only, the docket number 180900501. And then we can either vote for it or against it. It would be to go with essentially staff's recommendation for the AOC. We wait patiently for a motion.
Mr. Chair, if I may.
Yes, you may.
I think we should just pull this off and have a hearing. I mean, I think there's questions that I've heard from other commissioners that make me more concerned than I was when I first sat down here, so.
Mr.
Yes, Mr. Davenport.
So I would like to clarify that an AOC is a special proceeding under Rule 502. We don't immediately go to a hearing. If you do not approve the AOC, the commission remands the matter to the director for further proceedings.
Right.
And so I think, as Commissioner Overturf suggested, yay or nay on the AOC, and then staff can go back and work things out.
Good.
If they can.
Thank you.
Yes, Commissioner Ager.
So this is a question because I think we have two issues here that some of us are struggling with. And one is maybe just understanding exactly what happened. But two, Commissioner Overturf, could you repeat the fines, the issues with the fines or how they were classified, the concerns that you had about that?
So the concerns that I had were, number one, the collapsing of the violations of Rule 912A and 912B into a single violation for purposes of calculating the penalties. Number two, for classifying the classifying the violation as a minor impact, given that there was an emissions control device, because minor impact requires that there be no environmental impact. My third concern is that the classification, contrary to our enforcement guidance of Rule 912 as a Class 2 rule, as opposed to a Class 3 rule, which is what the guidance requires. And then my fourth concern is that they are approving a special project, which is expected to cost $99,000, but Cub Creek is receiving a credit of $125,000. And I don't think the additional $25,000 of credit has been sufficiently justified.
All right. Thank you.
Mr. Chair, could I just
Commissioner Boygan.
suggest, since Cub Creek is here, I think it's fair that we hear what they have to say before
Very
we
well.
proceed.
Before we make a decision, let's go ahead.
Thank you, Commissioner. Randy Dan for Cub Creek, and I'm Scott Bailey, president here for Cub Creek. We obviously believe this is a reasonable, fair settlement. We agreed to terms with the commission staff on this AOC. We don't ask that it be pulled off the docket. We don't want it to be pulled off the docket. We would like to move forward. We think, again, this is a fair, reasonable resolution of these issues. Commissioner Boygan, we understand the clarity issues surrounding flaring issues. We had those same concerns, but ultimately, at the end of the day, we felt that commission staff was being reasonable, and we do support the AOC.
So, Mr. Chair, I'll move to approve the AOC as it's structured.
Very well. Is there a second?
I'll second. Can I follow up with a comment?
Certainly. Is there any discussion?
I just want to say that I hear Commissioner Overturf's concerns and I have them too. I just want to, I guess what's leading me to second the motion is I feel like I'm having a little bit of a knee-jerk reaction based on what happened this morning, which is okay sometimes. But I do think these are separate cases, and just our discussion here and some of the plans we've made for looking into this issue in the future is putting a little more pressure on us to do some more thinking about how we address flaring or excessive flaring and venting.
Again, and so my comment would tend to echo that. All you were a little more eloquent than I am. I think staff's worked pretty hard to come to a reasonable settlement with the operator. There are some mitigating circumstances. However, again, can't let what we heard this morning color my decision. I'm going to support the staff position on this AOC. So any other discussion? Commissioner Jolly.
Question. Well, one thing that Commissioner Overturf brought up was they spent $99,000 on gas detection and getting $125,000 credit. Can you just explain how that came about?
I can. Commissioner Jolly, Rule 523 allows for the commission to consider a different ratio for public projects rather than 1-to-1. And in considering this specific public project, staff worked with Front Range Fire Rescue, who, as you noted in the AOC, was the agency affected by this, in coming up with something they felt like would have a broader regional impact than simply at this one site. So the system that's going to be funded by this public project would allow Front Range Fire Rescue to conduct more regional operations. Incidents can be monitored from up to 2 miles away, I believe, with the system that they're asking Cub Creek to fund. They would also be able to loan the system out to regional partners around the area. Staff believe that given the potential impact of this public project, it was worth upping that amount to the 125 that's reflected in the AOC. Staff felt like it was important to, instead of doing straight penalty amounts, staff felt like it was important to encourage public projects that could have this degree of impact on emergency response specifically.
I think I know the answer, but I just wondered why you didn't put a penalty matrix with this one or include it.
Could you be more specific? A penalty matrix. Staff did use the duration matrix in computing this settlement. It's reflected in
I didn't
towards the end of the penalty sections. Sorry. Just one moment, Commissioner.
On page 5, I think.
Yeah, 5 of 11, it gives the class and the impact. There's a column there.
Yeah.
Okay. Well, sorry, I missed that. I have nothing else.
Yes, Commissioner Egger.
I just want to clarify that I wasn't suggesting that Commissioner Overturf's comments were knee-jerk reaction. They were obviously, she spent a lot of time on this, and that's very separate from the items that we heard this morning. I was trying to not so eloquently say that I wanted to make sure that my reaction to that wasn't knee-jerk based on what I heard this morning, and that I supported the staff's findings today.
So I will say I did not hear you impugn any of her comments. I felt like that was made for yourself based on what you heard and not necessarily directed at any of the other commissioners. Very well. Any other comments? Very well. Are we prepared to vote? I think perhaps it may be useful to do a roll call vote on this one, Ms. Bryan. So again, we are voting on a motion to approve the AOC as set forth by the staff.
Yes, Mr. Chair, and this is solely for docket number 1809-00501. Chair Benton?
Yes.
Vice Chair Boygan?
Yes.
Vice Chair Holton?
Yes.
Commissioner Egger?
Yes.
Commissioner Hawkins?
Yes.
Commissioner Jolly?
Yes.
Commissioner McGowan?
No.
Commissioner Overturf?
No.
Commissioner Randall?
No.
Mr. Chair, I have 6-3.
Very well. The AOC is approved. Shall we move on? I believe we had, and questions about one other matter on the consent agenda. About Alta Mesa, you had some additional questions, Commissioner Boygan.
Just a real quick question, Mr. Chair. It's kind of the one I always ask. What happens if they don't comply, if they don't take the corrective actions? How do we enforce them? Is the suspended amount automatically reinstated, and is that just a Pyrrhic victory because there's no way to enforce it? It's the same old question we have with operators that are leaving.
I mean, in this instance, we would have an opportunity to enforce it. We could pursue Alta Mesa through whatever means we have available. I think also we do have the recourse through the order itself, stating that failure to perform any of the corrective actions is an independent order violation that the commission can pursue in the future. Having said that, since the signing of the order, Alta Mesa is continuing to pursue reclamation at the site. They're also pursuing a variance with the surface owner because in this instance, the surface owner did want some of the land to stay as it was modified by Alta Mesa. So they're continuing to pursue that variance. Alta Mesa has been engaged with reclamation staff, and staff has every indication to believe they'll continue moving forward.
Okay, that's helpful. So they're not planning on leaving?
As far as I'm aware, this is Alta Mesa's only location. So once they've finished reclamation here, they will be finished in the state of Colorado. This order doesn't include a provision similar to the Lawrence provision, giving staff discretion to remove their Form 1 and Form 10. But staff, from negotiations and discussions with Alta Mesa, our indication is that they would not pursue further operations in Colorado.
Okay, well, I don't have any issues with the specific order. I just continue to have concerns about what to do about situations like this, where we've got work that has to be done and operators that are leaving and may or may not be currently collectible, and how do we go after them and or their principals. But there's nothing further I guess I can say on this one.
Yeah, an ongoing concern, I think, for all the commissioners. Same issue, same concern. Very well. Any other questions about any of the remaining items on the consent agenda, consent enforcement agenda? Hearing none, are we prepared to vote on the balance of these items other than 180900501? A motion would be welcome.
I'll move that we approve the other items
on the enforcement agenda.
On the enforcement agenda.
Moved by Commissioner Boygan. Is there a second?
Second.
Seconded by, Commissioner Overturf. Yeah, all in favor say aye. Aye. Opposed, same sign. The balance is approved. I think we have the next item on our agenda is docket number 180100037. Ms. Prine, is that correct?
Yes, Mr. Chair. This was pulled out separately just so that I could kind of make sure everybody was on the same page. This is a corrected order. The original order was drafted based on the application and not the amended application. So the order was not consistent with the notice or with the amended application or the order that was actually approved. So we are just asking to correct the order to match the amended application. That's all.
And do we need a motion for that?
Yes.
Very well. Someone like to make that motion? Yeah.
I move that we correct the order as recommended by staff.
Motion made by Commissioner Hawkins to correct the order as amended by staff.
Second.
Seconded by Commissioner Jolly. Any discussion? Hearing none, please. All in favor say aye.
Aye.
Aye. Opposed, same sign. Thank you, Commissioner Holton. And that motion carries. We're I jinxed us by saying we were on schedule and we're now off schedule. Can we shorten up our lunchtime and maybe reconvene at perhaps, we make it in a half an hour, like 1:10? Commissioners?
Yes.
All right, so we will reconvene at 1:10. Yes.
I will not be here for the first matter, the extraction Larson matter. I'm recusing myself.
Very well. You get a longer lunch hour.
I do. I'll go to another room and isolate myself.
Okay. All right. I think you are allowed to listen, so if you want.
Fun's fun, but I'll.
Almost silence.
Well, I'm sure there's something else to do. All right, we will see you all back here at 1:10.